Good morning, everyone. You are the country of Kwame Nkrumah. I mentioned this name because we are talking of the African Union. Is one of the founding fathers of the chair, the vice chair of the commission, the rep, Minister of Justice and Attorney General from Ghana, distinguished guests, ambassadors, excellencies, professors, doctors, and dear participants. Good morning. I'm called Bruno Manza. I'm a legal advisor at the African Commission on Human and Rights Commission. I'm glad to be your MC for these next 2 days. I pray God for grace and to also meet your expectations for the intensive deliberation that we're going to have today. Once again, you are welcome. We have 2 intensive days of work. We are going to start by an opening, which will be chaired by the Excellency, the Secretary of the Commission. She's a bit late and will be represented by the Secretary, Executive Secretary, Deputy Executive Secretary, Serin Troyan Yassin. For this, you have to present our sincerest apologies for the logistics mishap that we had earlier on. We are so sorry, and we hope that we'll be able to catch up with the time that we've lost during the day. Let's start with the opening ceremony. I would like to invite to the platform Mr. Dwyan Yassin. Mr. Dwyan Yassin. He's going to moderate the opening ceremony with the Executive Secretary. Madam, the Vice Chair of the African Commission on Human and People's Rights, you have a statement to make as part of the opening ceremony. So if you, let's put our hands together. The first applause for the day. Madam, you don't have your headsets, do you? Can we have some headsets? The interpretation headsets. You can see on the screen, English is channel 1, French channel 2, Portuguese channel 3, and Arabic chapter 4. Channel 4, pardon me. Can you come to the high table whilst we put our hands together, whilst we ginger ourselves up this morning? Without particular protocol, Dr. Mohammed is also here. Thank you to support her. Slowly. Madam, I spent 2 days, intensive 2 days here. After that, the next on stage is Sylvia Adosu. I hope I've mentioned your name correctly. She's the Director of International Rights at the Ministry of Justice. She's representing the Minister of Justice and Attorney General. Madam, kindly come to the stage. You're welcome, Madam. Mr. Dwyan, that ends my role, so I'm handing over to Mr. Dwyan for him to take over the MC role. Thank you very much, Bruno, for your takeoff. That was very brilliant. Ladies and gentlemen, all protocols observed. I want to welcome you all to the conference today, which is focused on the effort the Commission is making and advocacy for the ratification of the legal instrument on human rights on the continent. Within the time I have, I would quickly ask Madam Vice Chair of the Commission to come and for her opening statement. Madam, you have the floor for your opening statement. Audience, the Vice Chair. Kindly put your hands together for her. Applause, kindly. Thank you very much for this rich statement calling for ratification for the legal instruments. That's a guarantee of human rights in Africa. I will now turn my attention to Dr. Sylvia Adosu. I hope I've mentioned your name very well. You are the representative of the Attorney General and Minister for Justice. So you have the floor for your opening remarks. The floor is yours. Thank you very much, Dr. Sylvia Adosu. Thank you for your timely statements. And I also want to thank Ghanaian Authority for the hospitality they've given to us and also your commitment. And now I'm going to give the floor to my colleagues Bruno for him to take over the role of the MC. I think we are going to have a coffee break and then family photo or group photo. Then Bruno, over to you. Thank you very much, Mr. Executive Secretary, Deputy Executive Secretary. Thank you, Vice Chair. Thank you, representative of the Minister. Let's put our hands together for them whilst they go back to their respective places. This is 10:45. It means we've done the coffee break and then the group photo, meaning that we are behind schedule. Now, with the support from my colleagues from the Secretariat, we'll go to the garden area to take a group photo, and then we'll take a coffee break down there and come back here. We should do all that in 30 minutes and come back here for the work to actually start. Thank you once again, and this is the end of the opening ceremony. Let's put our hands together and encourage each other because the day is going to be very, very long. We'll leave the high table to go first and then we'll follow them. High table first and then we'll follow them. Mohammed? Commissioner, can you take the lead? Then the rest of us will follow. As the walkway is very small, so we'll just allow them to go first and then the rest of us will follow them.
Time's against us. We are about 30 minutes behind schedule, and so we have to try to go faster. I hope you enjoyed the experience with the group photo and the coffee break. I enjoyed the garden personally. I think it's a very good location for coffee break. Thank you. Now we move to the second session of this meeting, titled Overview of the Status of Ratification of Human Rights Treaties in Africa. Now, we'll have a moderator in the person of Mr. Yassine Drayan, Deputy Executive Secretary of the Commission. So I'm going to give him the floor to lead the session. Thank you, dear colleague. Ladies and gentlemen, we are going to continue with the conference. We are now moving to the second session of the agenda. This session is on states' presentations on the status of ratification of human rights treaties in Africa, including the African Charter, the Protocol to the Charter on Human and People's Rights, on the rights of citizens to social protection and social security, Protocol to the African Charter on Human and People's Rights, on the rights of women in Africa, Protocol to the African Charter on Human and People's Rights, on the rights of older persons, the Convention governing the specific aspects of refugees in refugee problems in Africa, the African Union Convention on Ending Violence Against Women and Girls, and we will have Professor Hajar Guldish, Legal Counsel of the African Union Commission, giving us an introductory brief. Professor, thank you so much for having accepted our invitation. Thank you for your contribution to our to the ratification, the development of the ratifications document. Dear Professor Hajar Guldish, you have the floor for 20 minutes for your introductory brief. Thank you so much. Please, a round of applause for him. Thank you so much, Charles, for giving me the floor.
I would like to thank the Banjul Commission, and in particular, Mrs. Abiola Ojo and her team, for convening this timely meeting and inviting me to speak to the cross-cutting mandate between the Office of the Legal Counsel that I represent and the Banjul Commission, where the Office of the Counsel, as depository and legal advisor of the African Union, works with the Commission of Banjul to translate the political will into legally effective commitments. Excellencies, ladies and gentlemen, I will be providing verified figures to ground advocacy, universal ratification, and enhanced implementation. The encompasses, as presented by Yassine, 9 instruments, such as the Charter on Human and People's Rights, the Protocol to the African Charter on the Rights of Women in Africa, called the Maputo Protocol, the Protocol to the African Charter on the Rights of Persons and Disabilities in Africa, the protocol to the African Charter on the rights of older persons, the protocol to the African Charter on the rights and the eradication, the protocol to the African Charter on the rights of citizens to social protection and social security, the African Union Convention on Ending Violence Against Women and Girls, African Union Convention for the Protection and Assistance of Internally Displaced Persons in Africa, called the Kampala Convention, and the OAU Convention governing the specific aspects of refugees' problems. So the official status, can you go to the second slide? The official status from July to September 2025, I will present counts and percentages of the 55 member states and indicate entry into force, including the 15 ratification threshold where applicable. I will also situate these data within the African Commission on People's Rights and Human Rights, specifically Article 45 of the African Charter and the state reporting framework based on the Article 62 of the Charter to link continental obligations to national processes. The brief identifies universality gaps, instruments already in force that now require domestication and reporting, and those still below entry into force thresholds requiring targeted action. The indeed outcome is therefore to provide a clear evidence base for the meeting's common declaration and 4 dated instrument-specific commitments that states can operationalize immediately. Let's go to the next slide, please. In brief, this snapshot covers 9 instruments, as I said, under Banjul Commission monitoring preview, and I represent the number of signatures, ratifications, deposits, and entry into force rules, expressed also as percentage. No, please, can you come before that? The statistics and the table with the numbering of ratification. The one before this, please. Go back. So we will also express the percentage on the 55 AU member states. The brief is practical. Please, can you go to the slide before this one? The brief is practical. Numbers that guide cabinet, memos, parliamentary calendars, and deposit windows, and it also respects the context. As said Commissioner Janet, the political will, one of them, the resources, the cultural norms, the awareness gaps, and conflicts, all these challenges can slow ratification. So we will ask a question. Can we go now to the next slide? Can we ask a question now concerning these graphics, the number of signatures, ratification, deposits, and entry into force by instrument? As I said, we have 9. This is the context of our 2 days workshop. If we begin with the first one, the African Charter on Human and People's Rights, you can see that we have 45 signatures, 54 ratifications, deposits 54. Only Morocco did not sign nor ratify the African Charter on Human and People's Rights. The second one is the Maputo Protocol. We have 49 signatures, 45 ratification, 45 deposits, and this instrument is EPOS. The third one, ADP, the one on disability, signature, 40. I have a problem with the mic. The number of ratifications, unaudible, 17. The number of deposits, 17. entry into force, it was on the 3rd of May 2024. Can I have another mic? For the other person, the number of signatures is 20. Thank you so much. The number of ratification 17, the same with the deposits, entered into force on the 6th of November 2024. Nationality or statelessness, 0 signatures, 0 ratification, 0 deposits. This instrument needs 15 member states to ratify it so that it enter into force. Social protection and social security, 2 signatures, 2 ratifications, 2 deposits will enter into force after 15 member states ratify. The Convention Ending Violence Against Women and Girls, 6 signatures, 0 ratifications, 0 deposits. It will enter into force after 15 member states ratify. Kampala Convention, 40 signatures, 34 ratification, 34 deposits. It entered into force on the 6th of December 2012. The last one is the EU Refugees Convention, and we have 42 signatures, 47 ratification, 47 deposits. It already entered into force on June 1974. These are the statistics, and please, I send this PowerPoint presentation to the team. Maybe they can send it to you, because I think it is not very obvious when you are just going in that direction. Maybe it will be shared with all the participants. It does exist in PDF. And apologies for the website of the AU that is not, how to say it, is, there is problems with MIS. We are migrating to a new domain. So sometimes you will not find the status exact numberings on the AU website. We asked the team on MIS so that they can fix it as soon as possible. And as we are also experts, academics, civil society, we need also to have a very clear mapping of the number of signatures, ratification, to know more about our instruments. So we promise that we will update the website of the AU accordingly. Now let's go to the next slide, please. And we ask another question. How treaties take effect? This is the legal pipeline. We begin, as you know, with the signature. The signature signals intent and a duty not to defeat a treaty's object and purpose pending decision. That means the signature is not sufficient. We move to the second step. This is a ratification or the accession. And this is a sovereign consent to be bound under international law, substance, not ceremony. We come to the third step. This is the ceremony of deposit with the AUC, Cabinet of the Chairperson, through our office, the Office of the Legal Counsel, and we are the constitutive act that activate obligations within the AU system. After that came the entry into force that follows each instrument's rule. Several already in force and others, as I explained, are awaiting 15 ratifications. We have also the problem of domestic effect, and this is about implementation, and this turns on constitutional design. And as in the concept note, we have different member states with different system, dualist, monist, pluralist, so it does depend on each country's system, and on implementing laws, guidance, and budgets. So think in twin calendars, international calendar, that means deposit entry into force reporting, and the domestic calendar, that means bills, regulations, training, and where those calendars meet, people like me and you feel the law. This is not just a promise, it's a process, and it does need a holistic method. Next slide, please. On the continental snapshot, let us count and comment. So the charter, the first one, 45 signature, 54 ratify, 54 deposits into force since 1986. Near universality. As I said, this is the most instrument that is ratified by the member states. Maputo, the one on the second one, Maputo Protocol on the Rights of Women. 49 signature, 45 ratify, 45 deposit. It is in force, and for us, this is the continental backbone for women's rights. The next one, ADP, 14 signs, 70 ratify, 70 deposits. It is in force already. Now we have to move to implementation. All the person, 20 signature, 17 ratify, 17 deposit. It is in force since 6th of November 2024. Now we need to move to implementation. Kampala Convention, 40 signature, 35 ratify, 35 deposit. It is in force since December 2012. Now domestication is important. For all AU refugees convention, we have 43 signature, 47 ratification, 47 deposit. It is in force and it is mature enough, but harmonization is needed. For the social protection, 2 only on the 15, for the convention ending violence against women, 0 on the 15, nationality 0 on the 15. So for the ratification for the last 3 ones, this is the most important track for immediate advocacy, and you can understand that these conventions or instruments are, they are, how to say, they are just came in this year and the year before, so they are recent compared to the other instruments. That give us an idea why it is not ratified nor deposited. So we are now in a campaign, and maybe in the 2 days we have also to put on the table to brainstorm how we can be do the advocacy and be the ambassadors of our own instruments, especially women in law, when we speak about these instruments concerning rights of women. Next slide, please. Ratification rate. This is also in terms of percentage, 98.2% for the Charter, 81.3% for Maputo. That shows strong continental consensus on fundamental protections. For OAU refugee, it is 85.5% that reflects deep regional solidarity, while Kampala is 61.8% signals progress with room to grow. Both AGP and other persons sit at 30.9%, already in force, yet inviting broader participation. Social protection, 3.6%. Ending violence against women and girls, 0%. Nationality, 0%. They are not failures. As I said, they are recent instruments that explain why we are at very low level of ratification, with clear thresholds, and rates translate complexity into clarity, where to persuade, where to implement, and where to campaign. So they are also travel well. Colleagues will remember these different percentages: 98%, 85%, 81%, 61%, 30%, and 0, and what each demands. And behind every percentage you can see here, there is a family in Africa whose protection improves when these numbers move. Let's think about that. Next slide, please. For the universality gaps, a question: how many left to the 55 member states? To reach universality, the Charter needs only 1 more: OAU refugee 8, Maputo 10, Kampala 21. ADP and other persons each need 38, social protection 53, ending violence against women and nationality 55. So again, we are seeing these percentages, this numbering. This is actionable arithmetics. It turns objectives and adjectives into agendas. It turns agendas into dates. And for the 3 instruments, with 15 ratification, entry into force rules, the request is focused. I believe that our advocacy can cluster around AU summits, we have to prepare decisions, then deposit as a visible milestone, pair each number with a ministry, and a month, numbers will move when someone owns them, and you are here, the ambassadors, to move these numbers. This is how a meeting like ours here in Accra becomes a memory, and this is how a memory becomes a mandate. Next, please. Let's focus on some of these instruments differently. Let's begin with Maputo Protocol. This is the Protocol on Women's Rights with 49 signatures and 45 ratifications. Maputo is both a legal framework and a moral signal. Two states are not signed, Egypt and Morocco, and 8 have signed but not yet ratified, Burundi, Central Africa, Chad, Eritrea, Madagascar, Niger, Somalia, and Sudan. We place Maputo here. By the way, Maputo Protocol, just I come from Tunisia, we've done a lot, and we have here a representative from Tunisia to push. That's why I say everyone in the room is an ambassador for these instruments. We come back to our countries, we do all we can, including workshops, dissemination, having this kind of meetings with parliamentarians, with the people from the ministries, the legal counsel of the Ministry of Foreign Affairs. This is how the things can move. But today and tomorrow we are here brainstorming on how we can. Let's fix the challenges first, but also the main important idea and the objective of this workshop is to put on the table solutions to our challenges, is to give new, original recommendations so that we can allow our people in our respective countries to move, to believe in all these wonderful instruments. When you have time, go through them. And you can see that they are wonderful frameworks. What is missing? This is what we are asking today and tomorrow. So I said, we place Maputo here right after the analytics because gender equality is a bellwether of constitutional courage. Its provisions, non-discrimination, participation, sexual and reproductive health and rights of women already shape policy and jurisprudence continent-wide. For the remaining member states, our posture is respectful and practical. Model clauses, legislative roadmaps, clarity on reservations, and finishing Maputo says to every girl and woman in Africa, the continent is consistent, not conditional. It also sets the frame for the new Convention on Ending Violence Against Women and Girls, which adds the machinery for prevention and protection. Next slide, please. Concerning reservation and declarations in general, governance not dead ends, reservations are lawful, especially when we are in the issues of human rights. They are lawful, they are legitimate, but only when compatible with the treaty's object and purpose. We cannot empty the instrument from its essence with a lot of reservation. So there are tools of transition, not refusals. Several Maputo parties, for example, reserve on the Article 14, paragraph 2C, or marriage registration, reflecting constitutional dialogue at home. Our collective role is to keep the conversation moving. Interpretative clarity, and this is also one of the mandates of Banjul. Banjul Commission is not there only for promotion and protection of human rights instruments. They have also this mission of interpreting the rules, reflecting, as I said, legislative alignment, clarity, periodic review, or withdrawal. Peer learning matters. One country's drafting solution becomes another's confidence, and the depository circulates notices, and the Commission and its partners add substantive reasoning that reassures administrations and courts. Next slide, please, concerning the newly enforced, especially disability and older persons. The disability protocol has been enforced since 3rd of May 2024. Duties include accessibility, reasonable accommodation, participation, and data. Same with the older persons protocol that has been enforced since November 2024. Duties include social protection floors, health and long-term care, and access to justice. Because both protocols are now in force, our urgency shifts from ratify to implement. First, designate the national focal points, conduct gap audits, and issue administrative guidance to courts and frontline services. Integrate these duties early into African Charter, especially the Article 62, reporting cycles to anchor obligations in national systems. Ensure budgeted domestication with clear line items for training, standards, monitoring, evaluation, so rights become routine. Set an immediate deliverable, bring 3 practical implementation success, for example, stories, to the next session to model what works. And such visible delivery attracts new ratifications, sometimes more effectively than any communiqué. In short, delivery is our most persuasive form of advocacy. Next slide, please, for displacement and refugee regime. The Kampala Convention covers conflict, disasters, and development, included induced displacement with duties on prevention, protection, assistance, and solutions. Also, the second one, OAU Refugee Convention, it adds an expanded definition, non-refoulement, and recognition practices that complement 1951 Convention relating to the status of refugees and its 1967 protocol. Together, they urge coherence, harmonize IDP and refugee laws, clarify the rules, align budget lines to mandates. We have also the periodic reporting that can be braided to reduce the application and increase compliance, and partners such as United Nations HCR, OHCR, HR, REX, etc. fit naturally here, exactly as your agenda anticipates, and I'm sure when the commissioners in the next session will go through each of these instruments, we can discuss more. Next slide, please. 15th ratification track. These are 3 clear countdowns. Social protection stands at 2 on the 15th. Zimbabwe, Uganda deposited. 13 more will usher the right to social protection and social security into force. Ending violence against women has 6 signatories and 0 ratification. Commissioner Janet was behind the 6th signature. You can see that some person, because of its leadership, can do the difference, and we will continue. And by the way, the AU Law Week for the Office of the Legal Counsel this year will concentrate on this convention ending violence against women. It will be in December, and you are invited to that high-level law week that we are doing each year. Then last year, Office of the Legal Counsel had done its AU Law Week on the Malabo Protocol. So this is also our mandate as Office of the Legal Counsel to disseminate our different instruments. And this year, because it is very attractive and it is something that we need for the continent, we will just spotlight, highlight, and analyze the importance of this convention at our level, Office of the Legal Counsel, and we will invite Ambassador Janet to be one of our VIPs to deliver statements. So as I said, for the nationality, statelessness begins at 0, aligning with civil registration and vital statistics, reforms turns principle into passports and belongings. And these are winnable campaigns, not 55 decisions. but 15, and a focused diplomatic lane. The last slide, it is to have in conclusion some thoughts. Next slide, please. Going from statistics to action. This is a gentle reminder and a call at the same time. Numbers, as I said, become memory when we attach them to months and to ministries. Memory itself becomes mandate when we sign and deposit. Finnish universality, where the finish line is in sight. The Charter, the Maputo Protocol, the OAU refugee and widen Kampala, while deepening domestication. Deliver now, where entry into force has happened, disability and older persons, with focal points, audits, guidance, and first reports. So this is launch first 15 coalitions for social protection, ending violence against women and girls, nationality, with a clear cabinet and deposit choreography. Capture these choices in a concise common declaration, faithful to your concept note and practical for administrations. This is our objective in this 2 days workshop. We speak 6 languages in the AU. Here in this room, we speak 4 languages, but our message is one. Protection should be universal, just, and timely. What we cite here today and tomorrow in Accra will be felt by people in Africa who may never read a treaty but will live under its shelter. Thank you for your attention.
Thank you for this brilliant presentation that shows once again the statistics on the ratification rate of human rights instruments in Africa. We're not going to hold any discussions for now. We are going to move directly into the session 3. I'll ask my colleague from the Secretariat to ask the distinguished speakers to take their place, and then we'll have the opportunity to give the floor to participants to interact with them. I'd also like to ask my friends, my families in the Secretariat to share their presentations with the participants, of course, with the authorization of Professor Hajar Gildish. Now I give the floor to my colleague to call the participants to the high table. Thank you. So we just closed the second session of the first day of our work. Now we are going to move to session 3. The session 3 is titled Mapping the Progress, the Ratification and Implementation of the ACHPR Human Rights Instruments. During this session, we'll have about 5 or 6 speakers. It will be moderated by Honorable Aver Gava, Vice Chair of the African Committee of Experts on the Rights and Welfare of the Child and Special Rapporteur on Violence Against Children. For logistics, I think our podium is not big enough, so we'd like to ask the speakers to sit where they are and they would do their presentations from their seats. Sorry for this. Now, Honorable Aver. No problem. For those who want to come to the podium, I would give you the opportunity to do so. Thank you. A round of applause for Madame Aver Gaver.
Thank you very much.
the representative of the Honorable Attorney General of Ghana, Dr. Sylvia. May I recognize Honorable Commissioners of the African Commission on Human People's Rights. May I recognize Excellencies, distinguished guests, and all other protocols adopted by me. It is an honor to host this program. The Director of the Legal Council of the African Union just gave us an overview of the ratification processes and stages of this instrument. And so in this session, thank you. So in this session, I had to look specifically at human rights instruments. On the mapping, we'll look at mapping the progress, the ratification and implementation of the African Charter on Human and People's Rights instruments. In this session, I believe we'll be looking at the overview of what has been done post-ratification. We'll look at ratification itself and, by implication, issues of domestication and other treaty obligations are happening in states. I'll be hosting, all the commissioners are going to speak specifically to the instruments as we have in the program. I'm honored indeed to host this session and so speak to this instrument as we have. And it will be my honor to invite the Honorable Commissioner Ayele Deso, who is the chairperson of the Working Group on Extractive Environment, Human Rights Violations in Africa. Before he takes the floor, I want to note that even though this we have only 7 to every speaker, we have just over 65.
Thank you very much, Madam Moderator. May I kindly greet you all, distinguished ladies and gentlemen, dear friends, brothers and sisters. I wish to, first of all, thank my dear colleagues, members of the African Commission on Human and People's Rights, staff of the Secretariat, who as always help us in the execution of our mandate at the African Commission on Human and People's Rights in the promotion, protection of human and people's rights in Africa. My task is to speak to the African Charter on Human and People's Rights, as introduced earlier. But as I address you on the African Charter on Human and People's Rights, let me preface my intervention with a couple of observations. First, the law and human rights make a lot of assumptions about the state and society. by virtue of the nature of the making and historical evolution of law, particularly human rights law. Some of the assumptions are not necessarily assumptions that are to be found in the lived experiences and realities of many societies and states. And I think when we ask the question of that enormous bridge, that enormous divide between the promise of the African Charter on Human and People's Rights and the lived realities of people on the African continent, we have to be cognizant of matters that go beyond and above the so-called concept of political will. With all the political will that you may have in a country, the weight of history, the burden of history, the process of the making of the African state is not something that we can basically shy away and wish away. Prominent, globally renowned authors such as Mohammed Mamdani wrote seminal works on the bifurcation of the African state between the so-called modern and colonially imported or imposed artificial construct and quote-unquote the way the masses of people on this continent actually go about having their lives. This point that I'm making is not to excuse anything, is not to excuse the failures, ineptness, criminality of states and governments. It's not to excuse that I'm making this point. It is basically for us to be cognizant and conscious of the profound conditions that shape and inform what we would like to see realized on the African continent. So the burden of history is something that we need really to be conscious of and mindful of. And that is why I urge all of you, whenever you engage in analysis of the challenge that we face, to always read the preamble to the African Charter on Human and People's Rights. And one of the paragraphs speaks of being conscious of their duty to achieve the total liberation of Africa. And here is the most important part. The peoples of which are still struggling for their dignity and genuine independence. Political freedom from colonialism is the easiest part. The actual exercise by people of their right to self-government, to govern themselves, that is a totally, completely different stuff altogether. And we are far from that. So, with that, I wish to make a few points. One, we shouldn't also be caught up by, well, as lawyers, it's only natural that by virtue, by the dictate of our profession, that we pay attention to legal instruments. That's only logical and natural. But we have also to be mindful of not to be caught up by the temptation of having more detailed, more expansive elaboration of new instruments. As important as that is, the most important thing for the people of the continent, first and foremost, is are we even delivering the promise that has been made in the foundational instrument of the African human rights system, which is the African Charter on Human and People's Rights? Even on the foundations, on the promise, that is the baseline promise of the African human rights system. If we are not delivering on that, my fear is that we would be caught up and spread thinly in elaborating all kinds of legal instruments and end up not getting what we need to get. And that is why it is so profoundly important that we focus on the implementation of this important instrument, the African Charter on Human and People's Rights. Now, the African Charter on Human and People's Rights is a treaty. And it is the treaty that actually establishes the African human rights system. But the African Charter on Human and People's Rights is not just a treaty. It is a much bigger instrument. It is a historical instrument that actually speaks to not just the normative dimension of what needs to happen, but also to the historical, the socio-economic, the cultural dimensions of what we wish to achieve. So from that perspective, I think it's important to understand the historical and global significance of the African Charter, because the African Charter actually stands in par with any of the globally renowned human rights instruments that you can consider in terms of the scope of issues that it tried to address, in terms of the being a pioneer in collapsing the ideological divide between civil and political rights, economic, social, and cultural rights, in terms of giving equal legal status, not just to individual rights of humans, but also to the collective rights of peoples. Recognizing that the existence of the human, the individual, cannot be fully realized without being anchored in and as part of, in isolation from, the community, the society that he or she is a part of. We would be able to make sense of this world only through the language that our mom passes on to us. We will make sense of this world only through the culture that actually facilitates our understanding of what it means to be a human. So, in this charter, many of the other legal instruments that you made reference to, all of them have foundation in this charter. If you talk about the Maputo Protocol, it sprang from Article 18 of the African Charter on Human and People's Rights. If you talk about the Protocol on Older Persons, the Protocol on Persons with Disabilities, the Kampala Convention, name it, Article 12, Article 18, they provide the foundation and the basis for all of these things. And what is lacking is basically this one. I think we need, for the effective implementation of these instruments, as the Legal Council of the African Union mentioned, we need a constellation of actions and processes to be in place. Ratification is just the tip of the iceberg. And indeed, in the African context, ladies and gentlemen, the very existence of a legal instrument on and of itself, irrespective of ratification, can actually capture the imagination of people for people to demand that justice be done. So we, in this continent, make reference to the African Charter on Human and People's Rights in times past, even when in reference to countries which haven't ratified the Charter, by virtue of the fact that this Charter have already acquired the legitimacy in the minds of people by virtue of the aspirations of people that it embodies in the words that are inscribed in this Charter. And this Charter additionally requires what? Most importantly, as the Legal Counsel said, you and me individually in our respective places and positions should serve as ambassadors. But ladies and gentlemen, as I've been saying before here, truly and honestly speaking, in the conditions that we are in, beyond history, we have the burden of what I call the unjust and inequitable international economic relations, of which again the African Charter speaks of, which directly affects how we live our lives in this continent, from the extractive industries that were the foundations. Remember, slavery started because people came from across the ocean looking for gold here in this country. And in the process, they started to realize that with the plantation of sugar, they needed labor. That is how they ended up starting what French Howard called the scramble for Africans. I didn't say the scramble for Africa, the scramble for Africans. That was the predecessor to the scramble for Africa. The first scramble was the scramble for Africans. That is why today and this year we commemorate the African Union theme of the year on justice for Africans and peoples of African descent through reparations. And that the African Charter also speaks of. And that history, today, it defines, it's not just history. The extraction of Africa's resources started by the kind of asymmetric top-down relationship that has been established. That started during that time. And basically it ended up being what? It ended up being grafted into the international system. So if you look at international financial institutions, international economic relations, they owe their origin to that inequitable time. And ladies and gentlemen, it is not us at the African Commission. We have to avoid the temptation to feel that we are the vanguard of human and people's rights. We really have to resist this temptation. It is the ordinary men and women, the farmer who is toiling the dry soil. That is the beating heart of the quest for a dignified life. It is the woman in the informal market making many families the breadwinner, the provider. That is the heartbeat of the quest for a dignified life. It is the construction worker through tears and sweat build this building. That is the heartbeat of the quest for dignity and for freedom. And the moment we become oblivious of these people, then we will end up talking among the elites, the converted, and it shouldn't be about us. So in the African condition, what we need is basically to always remember and carry with us those people. And our role as the African Commission is really to actually espouse and give space and reflection and ventilation to the voices of those people. And always insist that we stand on that side of the equation, while always become a very reliable partner for governments who are willing and able to bear their side of the obligations, because they are the bearers of the obligation. I don't want to take any more time. I have taken already a lot. I will, however, end with an appreciation and an appeal to all of you that let the values of the African Charter on Human and People's Rights also be expressed in how we conduct ourselves on a daily basis, in how we relate to each other, in how we treat ourselves, in how we treat Africans. Whether or not we will achieve the full ambition of the African Charter on Human and People's Rights, I think, if possibly, yes, but it is neither here nor there, because many have already passed on, have departed us without being able to see the day when the full ambition of the African Charter is realized. And for their work, for their effort, in their name, let's rededicate ourselves to the values in the African Charter on Human and People's Rights, which anchors everything else, every legal instrument that we speak of. Madam Moderator, thank you for your patience.
Thank you very much, Honorable Commissioner Dasto. He spoke to us and left us with a lot to introspect about. He juxtaposed the provisions of the Charter and the lived realities that we have in Africa. And so he painted a picture of a people who are in reality struggling with their political, economic independence. And recognizing that the Charter is the bedrock of all human rights on the continent, have we, as a people, delivered on the foundations and our commitments to the Charter? Like I said, it leaves us with a lot to think about. It calls for deep introspection and self-analysis. Thank you once again. And so the next, we are going to have Honorable Commissioner Litha Musimi-Ogana, who is going to speak on the protocol to the African Charter on Human and People's Rights and the rights of persons with disabilities in Africa. So speaking on behalf of the chairperson of the working group on older persons and persons with disabilities in Africa. She has 7 minutes. Interestingly, she's going to have 2 sessions. And so maybe she will just progress from one to the next. But I will be here to prompt her when she ends the first one or when she ought to end the first presentation. And then she will take on the second presentation, which will be on the protocol to the African Charter on Human and People's Rights relating to specific aspects of the right to a nationality. Protocol to the African Charter on Human and People's Rights and the rights of older persons in Africa. Here she will be speaking on behalf of the chairperson of the working group on older persons and persons with disabilities in Africa. So I put 7 together and I give you 50, Madam Commissioner. If you feel to sit, take a seat.
Thank you. Our able moderator and vice chair of the Children's Committee, vice chair, commissioners present, our guests of honor from the Ministry of Justice in this country, delegates, panelists, ladies and gentlemen. Honorable Commissioner Marie-Louise Abomo is very passionate about the presentation I'm going to make on the two protocols, which she is a frontline commissioner. And so on her behalf, I'll try, but bear with me if I do not meet the threshold of her passion. I will try. Your Excellencies, ladies and gentlemen, I wish to extend and apologize for my esteemed colleague, Honorable Commissioner Dr. Marie-Louise Abomo, the chairperson of the Working Group on Older Persons and Persons with Disabilities, who will be with us here today, and on whose behalf I am making this presentation. Progress of ratification and implementation of the two protocols falling under her mandate of these mechanisms for the last year. The state protocols are one on the rights of older people and on the rights of persons with disability. Madam Moderator, to make our life easy, I will present the two protocols as one document because that is the form in which they came to me. Your Excellencies, ladies and gentlemen, thank you. Our legal counsel has done a wonderful job in trying to set the stage, and so there is no need to go into the technical details on the adoption, the status, signatures, ratification, and entry into force of these instruments. So I will go ahead to focus on the presentation based on key observations that Commissioner has made. This brief presentation covers the vision of her working group through its continuous monitoring of the situations of rights of older persons and persons with disabilities in Africa. The first observation is on the national legal frameworks on older persons. It is interesting to note that all African countries have attempted at various levels to regulate the situation or rights of older persons in Africa, either specifically or generally, including constitutional recognition of the need to protect the vulnerable groups. The working group noted that at least 26 African states have enshrined in their constitution the protection of elderly persons. Among these 9, except 5, all other state parties to the protocol have constitutionally guaranteed the rights of older persons. Countries which have specific older persons are at least 30. Almost in all the countries, there are programs, schemes, and plans to address specific needs of older persons. It is equally notable that in all African countries, specific institutions, ministries, or agencies established to deal with the matters pertaining to older persons. Despite the challenges they face here and there, a few interesting national developments at legislative level could be pointed out and include ongoing amendments, process of Older Persons Act of 2006 in South Africa, and the Older Persons Bill 2024 in Kenya, also in the process of adoption. Observation 2, on national legal frameworks on persons with disabilities in Africa. The Commissioner has, again, based on the mapping above, and based on what the legal counsel has presented, wishes to make the following observations. The first observation is that at least 40 African states have enshrined in their constitutions the protection of persons with disability, and among these, except two, all state parties to the protocol have constitutionally granted the rights of persons with disability. Secondly, countries which have specific legislation on persons with disability are at least almost all of these countries have programs, schemes, and plans to address specific issues of persons with disability. Thirdly, all African states and established to deal with matters pertaining to rights of persons with disability. She gives a few examples, and out of these positive developments regarding the protection of rights of persons with disability, Kenya could be commended for its enactment of the Disability Act 2025 to align with the Protocol on Persons with Disability and the UN Convention. Also, various similar initiatives have happened or are ongoing on the continent to ensure that national legal frameworks meet minimum standards set out in these protocols. Further, we have witnessed very proactive measures aiming at ensuring that no older persons or persons with disability is left behind. The Commissioner gives of Cote d'Ivoire, which is both touching and demonstrates that with strong political will, all barriers to vulnerable groups could be lifted and that they could be made to participate in society on equal basis with others. In the Ivorian case, a young disabled person who was granted all conditions to undergo academic exams as his medical condition due to disability necessitated admission to the clinic. Perspective conditions. The perspective of the working group are that further positive developments in the situation above would continue to happen, and that is why there is a need to implement strategies elaborated by the working group, which identifies practical steps or actions to undertake upon ratification by a state of the protocols. In fact, this strategy states that it is to be done on the short, medium, and long-term basis to give effect to the obligations contained in the protocols. Here is not the time to elaborate on this strategy, and the working group is available to discuss this strategy in detail with stakeholders in another occasion. The working group has also undertaken elaborate guidelines for reporting to the Commission on the protocols in the framework of Article 62 of the Charter and intends to bring this task as soon as possible, Concerning recommendations, below are some that are worth considering among others. The Commissioner has made 4 calls of action, and I would like to go through each one of them. The first one is call for universal ratification of protocols. The working group will continue its advocacy of all these remaining protocols by member states to make sure that it achieves ratification, even if it is in the long term. The latest action from the working group on this objective is the correspondence addressed to 54 member states last June to congratulate those who had ratified the protocol and protocols and advocate for those who have not done so to do so. This action and present activity on continental ratification and implementation is believed to get us where we aim to get to. The second call of action is for deepening the interventions of states and other stakeholders to address multiple vulnerabilities for vulnerable groups, for both the older persons and persons with disability in the context of the crisis. The concept of multiple vulnerability for older persons and persons has never been so salient as the continent experiences violent crises and other threats to human rights. In fact, while in relatively normal circumstances, these vulnerable people groups struggle to enjoy their human rights on equal basis with others, this has become more challenging in troubled times and circumstances. The effect of crisis is dire for older persons and persons who live with disabilities. So they need minimum guarantees to be able to survive this extraordinary situation. The Sahel and other environments and circumstances continue to impact negatively and disproportionately to people with disabilities and older persons. The third core of action is combating stigma against vulnerable groups for both older persons and persons with disabilities, and the recommitment to the protection of all their rights. Finally, it is in order to call upon each and every one to change the negative perspective, consciously or unconsciously, lingering in our communities and minds when it comes to dealing with older persons and persons with disability. The stigma associated to them very often is the starting point for their discrimination, unequal, unfair, and just treatment, leading to violation of their human rights. We must realize that we are all not safe from both conditions as long as we still live, and that all measures toward the protection of rights of these two vulnerable groups also guarantee us as well. The fourth call from the Commissioner is alignment of all legal frameworks and undertakings from states and stakeholders to standards. The challenge to address here is to ensure that the existing or would-be national legal frameworks, plans, programs, and policies meet minimum standards agreed in the protocols. There should be an analysis frameworks to ensure alignment to the protocols. This analysis is possible and can be conducted through a review of state reports under Article 62 of the Charter, as well as isolated assessments depending on capabilities of the working group and its partners. One means to ensure change in all undertakings relatively to rights of older persons and persons with disabilities is their participation and proper consultation as better what is for them. This ensures ownership. At this, I just want to pause before I conclude to check if there are any older persons or persons with disabilities who have been invited to this workshop. Do we have people under that category? We've just been called upon to make sure that they participate. Do we have any? Because I have to report this to the Commissioner. I think this is a way to sensitize us that next time we are talking about the ratification of all protocols, including these two, that category is also present. It is with these few working elements that I wish to end the presentation of Honorable Commissioner and look forward to your valuable insights and interactions for further brainstorming on practical actions aiming at protecting all rights of older persons and persons living with disabilities within the context of the two protocols. On behalf of Commissioner Abomo, the frontline commissioner for these two protocols, I wish to thank you for your kind attention. I submit.
Thank you very much, Commissioner Lisa Usini Ogan. She was able to buy us back a couple of minutes. Can we give her another round of applause? She gave a picture of countries, of what countries have done in respect to this instruments on older persons and persons with disabilities. And for those who have specific legal framework, there is a level of guarantee under the national constitution. It's gratifying to note. And it is commendable that the working groups have provided guidelines for reporting. I think this summarizes all that needs to be done at that level and also highlighted some good practices. To me, the call to action that talks about deeply intervention by states to address multiple vulnerabilities of this group summarizes everything because this multidimensional issue for states to step up budget lines for this group and to capacitate mechanisms that are mandated to protect this group. Thank you for the presentation. I may just permit me to just point out, in sharing with you the status of in Nigeria. Nigeria has, to Kenya, Nigeria also has the Disability Act, which was actually enacted in 2023 and has set up a commission on disabilities. Thank you so much. So we are now going to call on the third presenter, who is Honorable Commissioner Selma. She's a special refugees, asylum seekers, displaced persons, and migrants in Africa. She's going to talk on the protocol to the African Charter on Human and People's Rights relating to specific aspects of the right to a nationality and the eradication of statelessness in Nigeria, in Africa. So sorry. She also has topics to speak on. She would go ahead, indeed she has three. She will go ahead and speak on the Convention for the Protection and Assistance of Displaced Persons in Africa, the Kampala Convention. And finally, so the OAU Convention aspects of refugee problems in Africa. Madam Commissioner, you have the liberty to break and introduce the next subject matter. And going by the time, you have 21 minutes to address this issue.
Distinguished representative from member states, Excellencies, distinguished reps and international organizations and regional organizations, Madam Legal Advisor, AU, and pardon me, the reps from the national human rights organizations, all protocols observed. I was saying at the special rapporteur for refugees, asylum seekers, displaced persons, and migrants in Africa. Allow me, ladies and gentlemen, to come in on a session on a very clear attention. Put law on the effect of relativity. How I would say, as the presenter said, three instruments, additional instruments, and decisive instruments. Protocol to the African Charter on statelessness, on the Convention of Kampala on Protection of Displaced Persons in Africa 2029, and finally, OAU Convention governing on specific aspects of refugee problems, Protocol to the African Charter on Human and People's Rights. My presentation is going to show the specificity of these normative, their synergy, and faced with forced displacements and vulnerability of identity, which also requires of us today. Ratifying without delay, domesticate without any wasting much time, and put in place effectiveness. The ambition is very clear today, mobilize political will from member states to transform the binding legal documents to protect vulnerable people in the society. Ladies and gentlemen, if you are here today, is also to put at the center of our agenda an imperative, legal imperative, and political imperative aspect on every person to have nationality and eradication of statelessness in our continent. This is not something that we cannot do if the conditions for existence of millions of people in Africa is the right to have access to have rights. For us to be able to achieve there is very clear. The protocol to the African Charter on Human and People's Rights relating to specific aspects of the right of nationality and the eradication of statelessness in Africa, adopted on the 18th of February 2024. But before I go further, allow me, ladies and gentlemen, to remind the gathering that the reason for us to be very concrete on this one, nationality or citizenship is very important. We enjoy from independence when it comes to us. But not to have nationality or citizenship is to be marginalized. Is to not to find your place, to be invisible in the eyes of government and the eye of the law. This reality does touch, unfortunately, probably millions of people on the continent. Shows is because of several causes: lack of legal framework, discrimination, arbitrary prevention of citizenship, and also to affirm that nationality conditions the existence of all other human rights. It is very rare that by the protocol on nationality and statelessness respond to the issues of rights in Africa that can be mobilized. The protocol deals with specific issues relating to Africa, legacy of colonial boundary, cross-border identity, discrimination and law, insufficiency of registration at birth, and also by responding to justice mechanism, prevention of statelessness, attribution of nationality to children found, and other solutions. The protocol also provides opportunity, operational for that matter, to the service of the rights of people in Africa. The adoption of this protocol represents an historic moment and also a major strive for the African continent on the legal front. That also shows today, and for the first time, an instrument that is binding, ensuring the promotion and protection of right to nationality, and also the prevention of eradication of statelessness, contrary to dignity to human and the laws that is required by the person. The adoption of this protocol is also a strong signal that was sent by the African Union to the international community of its major contribution to the support of the world, support for the statelessness in Africa, in the world, launched by the Human Rights Commission, and also inspiration for the Agenda 2063 to make Africa a major partner for international affairs. Ladies and gentlemen, the adoption of monthly, as was recalled from the beginning of this meeting, does not even bring bind on us, but adoption is also a promise. Ratification is an obligation, but entering into force gives us the force that is required. Implementation then shows the reality. Once these steps are not respected, the test has not have any power, does not protect. On this basis, a study was done to show that this was recalled by the legal counsel this morning. Till today, unfortunately, after 1.5 years of adoption this protocol, no signatory and no ratification on the African continent. I recall you that we need 15 ratification for it to enter into force as required by the AU conventions. I remind you this, not to blame the member states, but to fix an objective and that we have to go through to achieve this. This protocol brings a lot of major contribution to the African Charter by consolidating its normative framework, and also informs once again in a clarity that is effective resolution of nationality and eradication of statelessness in Africa will require ratification, universal ratification, and effective implementation and regulars of various provisions. On this, no? This ambition is very realistic because it involves on regional precedents. The commitment of member states of the ECOWAS Commission on the Abidjan Declaration, followed by the international conference in the Great Lakes region, in the Brazzaville Declaration, also shows that political feasibility of the eradication of statelessness in Africa. And our Commission sees this opportunity today to invite member states to transform this commitment by signing and operationalizing of this protocol. In this perspective, we are also adding our voices and to the other member states as part of the African Charter to activate the necessary mechanisms to sign, ratify, and for us to achieve quorum on this. And this requires simultaneous mobilization from our partners. We are reiterating our call for the AU Commission and the CSOs in Africa and the human rights organizations to conduct effective advocacy for the entry of this protocol. Ladies and gentlemen, you might also understand that our objective is very ambitious. It's not only to ensure the implementation of this protocol, but also to be able to ratify universal ratification of the protocol to the Agenda 2063 and the objectives of the Sustainable Development Goals of 2030 for able to build Africa that we want. Political will has to be translated into an act, ratified now, domesticate without delay, enforce the law now, and this is the only way we can collectively, without statelessness, who have a place in the continent and give this convention its legal banking. Before I conclude, I want to remind you that in the spirit of responsibility, collective responsibility, and shared responsibility, I'm inviting every member state today here by leaving this conference in Accra to have the commitment to take acts to promote the signing of this ratification of this convention. Let's make this protocol a living document. Enter into our force quickly by requesting 50 ratification and domestication of this in our national laws, and constitute a major test for credibility for the African system on human rights. A test of credibility that will facilitate or help the translation of this into concrete activities in Africa, transforming this together, the commitment written for those who does not have nationality, does not enjoy this right of nationality at all. Thank you very much. Allow me, ladies and gentlemen, once again, for us to save time to continue to present to you another convention that is very important to us, which is very equivalent on the continental and regional level, which clearly face the responsibility in regarding internally displaced people. Convention of the protection and assistance of internally displaced persons in Africa, commonly known as Kampala Convention. An instrument to today, the only one in the world that is binding, dedicated to the IDPs. The Kampala Convention does not, it's a must for us to sign it. It's very normative and very clear, and protect the rights of IDPs, and has responsibility for assistance whilst people are IDPs, sustainable development for these group of people, and also provide security and dignity and local integration under the responsibility of national level, national government. As today, as was recorded by the Legal Council of the EU, 34 countries have ratified, 10 have signed, and 11 have signed, not ratified. More than 15 years after adopting the Kampala Convention, more than 10 years after it came into force, today is not yet for us to analyze anything. It's for us to take decision. Ratification requires progress. It takes time, but we have to do it. It says adoption, you don't follow up by ratification and domestication, but adoption for that in the national laws remains took a very long time. As was recommended since morning, ratification opens opportunity, but incorporating and domesticating it in the international law makes the law into force and becomes part of the people. That's why the EU is adopting in 2018 a law on IDPs that protects people today as a guide for national lawmakers. Ladies and gentlemen, the legal registry today starts today to recognize the realization of member states have adopted the domestication of this law. Some are trying to conduct a process, and they have the advanced stage. The message is very clear. Once the political will exists, the norm becomes operational. The specification of this convention, the Kampala Convention, is about accountability, because Article 14 of this convention imposes regular reporting to the African human and people's rights on implementation of these based on Article 62 of the convention of the African Charter. On today, only few member states have confined to that. Just 3 out of the member states of the AU. Accountability is not a bureaucratic process, but it's an legal obligation. It's a tool that requires us opens the opportunity for a dialogue, and also us to get assistance as targeted. On it, ladies and gentlemen, to insist that 4 requirements, legal requirements that structure the action. First of all, by ratifying, by member states are invited to be committed, activate the processes to activate and also domesticate the Kampala Convention by adopting national laws that will conform to the convention by also supporting on the AU Charter, and also taking into account the laws will not be a dormant legal framework. Ensure implementation. How? By identifying the indicators on IDPs, shelter, water, care, registration at the local government. And the data is very important, but because we cannot improve without data, we can't improve if we don't know what we want to improve on. So for this, we have to put in place mechanism to collect data, disaggregated data that are viable to protect the people. And fourth, we are also inviting the EU to accelerate the operation of the National African Human Rights Agency, and to provide the necessary logistics for them to be able to function in terms of crisis in Africa, for them to also come up with African solutions to African problems. Ladies and gentlemen, the contents also requires us to move long-term displacement exile into neighboring countries once restrain budget. These displacements leads to so many issues: conflict, arms, national disaster, lead to climate change, and so on, and some other development projects. The figures show today that there's a need for us to run fast. There's more than 40 people who are internally displaced in Africa, more than 10 million just in Sudan. Ladies and gentlemen, allow me to conclude by a clear legal evidence. The feasibility is shown. The laws are there, national processes are in progress, and organs are appointed. But today, we have to operationalize this and give and be accountable to it. And it requires legal actions, adoption of laws, accountability mechanism needs to put in place through reporting to the AU Commission. It's really by throwing this that these members of the laws of the countries will be respected, that you can transform these commitments written on the IDPs on their continent. Thank you very much. And now I'm moving straight to the third convention, if you allow me. Ladies and gentlemen, allow me to draw a conclusion on this presentation by the presentation of another convention that comes to add value to the African Framework for Protection. That also continued to today. The beginning of it has been more than 55 years to guide our progress. That is the AU Convention concerning the specific aspects of refugee problems in Africa. This convention does not only have added value to the international framework imposed by the Geneva Convention 1951 on the Statute of Refugees. 1969 Convention reconfigured the protection of refugees in Africa. Its specification, normative regulation, is very clear. It expands the definition of refugees, people who are moving not only from persecution but also from aggression, the occupation and events that are harmful to them, that characterize regional crisis in Africa. Today, this is our reality in Africa. There's a space for protection that's adapted to mass movements. Ladies and gentlemen, before I go further, I would like to remind you that what makes our political commitment is the spirit of philosophy of goodwill. Because we are, I am because we are, because Africa is one continent. The 1969 Convention brings about this positive solidarity to share common responsibility. And among other things, it's not just a slogan, it's a requirement that we need to be committed to by member states individually. Why this specification counts is still lingering on today? Because Africa, our continent, has more than 10 million refugees and asylum seekers. In a context where you match this prolonged armed conflicts, economic pressure, and effects of climate change that's actually create problems and move people to cross the borders. Our context for 1969 is not real as of today. By targeting traveling movement, this integrates legally what the collective it has to do with climate change, and it requires a group and a collective decision that is legal. On this, the Convention of 1969, I would say, should serve as a legal door for cross-border movements linked to climate change by authorizing we have to talk as it was this morning on the budgetary constraint. It is clear that the host countries often are faced with budgetary constraint. severe in terms of funding to fund these support for refugees, but sometimes they also take care of the refugees. This constraint is not marginalized. It's conditioned effective to the right of these people that need to be protected and the promise of social inclusion. So solidarity by 1969 Convention should become operational. Shared responsibility supports regional mechanism to alleviate suffering from the host country. And beyond and this, there are other simple consequences and firm. One, open the borders, open the door of protection when the need rises, by having access to people going through group and not by indulgence, but also by existence, African normative assessment. No refoulement, sending the people without any examination is beyond our standard for 1969 and this Continental African Commission. And also protects against non-involvement to danger, the principle of non-refoulement. You don't have to send the people back to where they are run away from. That's community. At the end, ensure dignify where we seek the promise of 1969, verify the access to education, healthcare, work, and social protection, because the inclusion is dignity. It reduces dependence and supports the community and stabilizes society. Allow me, ladies and gentlemen, allow me to ask a question that is current, that has a link with the 1969 Convention, that is externalization of management of immigration and asylum seekers. The international cooperation is legitimate. The delegation of our obligations are not. The mechanism today is to treat asylum seekers or transfer people to other African countries, particularly when they are not from those countries, are incompatible to our commitments. No refoulement, access to judges and lawyers, and corporates. These are some of the obligations. All sort of corporations should have clauses that will safeguard and a control system that would be traceable of transfer, and our agreements cannot in any way bring down the level of protection guaranteed by 1969 Convention. Ladies and gentlemen, it is this conference should think and take decision on 1969 Convention. Some member states, as was recalled this morning, have not signed this ratify the 1969 Convention. Some have not even fully domesticated the requirements. Some of the member states together are at a point, at different level, the intention, but the recommendations are still there. Allow me, ladies and gentlemen, to affirm that it's not only difficulty, technical difficulty, it's also an issue of political will. Ratify is to say it, but implementation is to actually keep your promise. From what was made, the progress that have made on other instruments, we are also proposing 3 commitments that will give power to the specification of the Convention, 1999 Convention. The first commitment is to fill the gap between the Convention of the 1999 Convention by member states who have not done that. Second commitment, transform the norms to results by integrating these tests into our national laws. And the African Commission on Human and People's Rights has to take responsibility and push for this agenda. And third commitment is to fund solidarity and totally refuse external pressure. So there should be common respect for commitment. We are all conscious of the concerns of security concerns and the maintenance of public order, and the pressure on public services local tensions and lack of resources. But our norms, our African norms of 1969, also gives us the necessary tools to respond. Protection is an legal obligation, not a favor. Solidarity is a operational principle. Cooperation should never become, should not be abused. Whatever you decide today in Accra, the method of the 1969 convention becomes the method for all our policies at the borders, in our budgets, and in the sanity of ratification meets the effectiveness of law. And every state should take this conference as a point where they can think about and ratify, instrument ratify today and law adopted today, tomorrow, and enforcement of the requirements of those law. And beyond this, the Convention of 1969, and to be able to put our history and our African value in the legal framework. The philosophy of mutual force us to be to be joint hands. Anybody who seeks protection today will identify a territory, a legal framework to go through, an opportunity to live in dignity. Thank you very much for your kind attention.
and so many other safeguards of women, both in armed conflict and displacement. So just like the African Charter, actually, is a parent for all of that history. And finally, the person responsible for this is the lowest students actually cover. So this is why we consider it as one of the
So this is very important. But it's important to know that as of September 2025, reporting compliance among the state parties remains minimal. As of the 46 countries that have actually ratified, only 21 have submitted their reports, leaving 24 countries yet to submit their report. This is almost about 50%, and we need to do more. So we call on those countries that have not actually submitted their state reports to the Commission. So our appeal is for ratification, for those who have ratified, domestication and implementation. For those who haven't ratified, ratify. For those who have entered reservation, please work towards lifting the reservations. But most importantly, we can only play our role in terms of the monitoring and accountability if you submit your report. Because it's not about calling you out. It's about engaging in constructive dialogue and ensuring that we can make effective recommendations so that when we come in country, the distinguished representative from Ghana has informed me that we're going to have a promotion mission to Ghana. So we'll be following up on recommendations we've made to you through the state reporting obligation, through the promotion, previous promotion missions, and also through the communication procedures. So these are some of the things we do. So in conclusion, achieving universal ratification of the protocol remains a critical priority for our African continent as a whole, and the mechanism of special rapporteur on the rights of women in Africa. 46 countries have ratified, as I've indicated, but it's essential that we work on implementation, ensuring that this is reflected at the national level, in the legal framework, constitutional legal framework. We're encouraging the remaining EU member states to ratify, and this should be our central focus in terms of advocacy, and we are ready and willing to assist you in doing so, together with not only the African Commission, the Special Envoy on Security, the aid and the Directorate, and civil society. We have what we call the All for Maputo campaign, and this campaign is a multi-stakeholder campaign. It involves everybody, all the stakeholders, and we always work together. And it is important to realize that unified ratification will strengthen the normative authority of the protocol, signal collective commitment across this continent, and provide a firm foundation for consistent implementation. Ratification, when coupled with genuine domestication, transform a form of legal obligation into tangible protection that advances equality, justice, and empowerment for women. That brings me to the end of my presentation under the Maputo Protocol, with the final call for ratification, implementation, domestication, and lifting of reservation, and a commitment from the African Commission, especially in my capacity as a special rapporteur on the rights of women, of our willingness to help states. In fact, it may be interesting to note that currently, in a quest to help states to domesticate and implement the Maputo Protocol, we're embarking on a very important project. It's a resolution that was adopted to prepare to help member states the instrument at the national level, and you'll be all involved in the whole process of the preparation of that model law. So now this moves me to the AU Convention on Ending Violence Against Women. Again, the question will be asked, you have the African Charter, you have the Maputo Protocol. Why do you need to have a dedicated instrument on ending violence against women? But it is important that we recognize that the AU Convention on Ending Violence Against Women, which was adopted in February 2025 as provided, as we've been informed by the Legal Council, represents the most ambitious regional effort yet to eliminate gender-based violence. It is important to note that it doesn't stand on its own. It is grounded on, first of all, the African Charter. It builds upon the Maputo Protocol, so they all actually go together. But it goes further by addressing forms of violence that earlier instruments did not explicitly cover, including the rising menace of femicide within our continent. In most countries, when we deal with femicide, they just consider it as another act of homicide. But when it becomes actually very prevalent, it actually calls on us to act and to recognize it and call it what it is. It also deals with technology-facilitated violence and abuse against women. I mean, I don't need to reiterate the challenges of digital violence against women or technology-facilitated violence against women. It also deals with trafficking and violence in humanitarian settings as this relates to women. I think our colleague has mentioned the issue of violence that takes place in humanitarian settings generally, but this is now situated with where women are concerned. And most importantly, the Convention mandates the Commission to be monitoring and interpreting the mandate. And this is very important because having that so ensures a very comprehensive and consolidated platform, not fragmented in an accountability mechanism. So it's very important, and we've been told that despite its groundbreaking nature in terms of focusing and being the first legally binding instrument focusing on violence against women, the African Commission has always been interrogating states and holding states accountable on matters related to violence against women using the Maputo Protocol. But this is now, and also in doing that, we've actually issued interpretive text to our soft law system by actually allowing the rights. But those soft laws are soft laws. This is the first time that we have what will be a legally binding instrument once it enters into force. But what is, as the Legal Council has informed us, right now we have only 6 states that have actually signed. It's commendable because it's going in the right direction. We have Angola, Burundi, Djibouti, the Democratic Republic of Congo, Liberia, and the Gambia that have signed. Ghana, we are in Ghana. Ghana has not signed yet. I think I'm looking at the representative of Ghana. I need to get her attention, Commissioner Lita, so that we're making a direct call to Ghana. We're in Ghana. We're hoping that by the time we leave Ghana, we'll have a commitment for Ghana to sign and ratify the AU Convention on Ending Violence Against Women. And it may be interesting to know that your head of state has been one of the champions of the AU Convention on Ending Violence Against Women. So it's just naturally and makes sense that we not only get that commitment, but action so that we get that instrument ratified. There are so many other member states that are also, we call on you to do the needful so that the instrument can enter into force. We're hoping that by the next summit in February, we'll have the required 15 number of ratification for it to enter into force. It is not impossible. We hope to have a convening on the margins of the 85th session of the African Commission in October, and we're hoping that some of you who are here will be invited so that at least you come so that we'll continue the advocacy for ratification and enter into force of the AU Convention on Ending Violence Against Men. So this is also very important. I think a lot of issues have been raised in terms of, and it might seem very repetitious if we go over some of the challenges and some of the why it is important to ratify. But I think some of the things I want to focus attention on in terms of just flagging some of the provisions of the AU Convention on and the urgency for ratification, as the fact that the issues that are provided for in the convention, which is I talked about the rapid rise of technology-facilitated violence, with the expansion of digital platforms, women and girls are increasingly exposed to online harassment, non-consensual image distribution, cyber stalking, and coordinated online attacks. So it is important that the instrument that actually gives us the legal authority to say this should not happen should be actually ratified. I talked about violence in humanitarian conflict and post-disaster settings, which is also very important. I also mentioned femicide. But most importantly, the convention emphasizes intersectionality, recognizing that women and girls experience violence differently depending on age, displacement, and other identities. It is therefore responsible states to address this must actually make sure that we ratify the convention and ensure it enters into force. And of course, when we ratify, eventually, for this one, not start talking about implementation, but sometimes it is important to talk about implementation at the point at which you are ratified. Because otherwise, states will just ratify and tick the box and then go to sleep. So as you enter that ratification, I'd like you to also focus attention on that. Here, civil society also in this process, organizations will amplify survivor voices, advocate for ratification, and provide cannot deliver, because civil society is there to complement what the state does, so they should play their role. Once the country has ratified, also civil society ensures accountability, indicated, and also in community harmful practices. So ratification therefore creates a space for stronger partnership between government and other stakeholders, ensuring that the convention's commitments are translated into lived realities. We keep talking about lived realities of the African citizen. Let us move swiftly from aspiration to reality, and together make violence against women and girls a thing of the past. So I'll end by fervent call and appeal once more for ratification, universal ratification of the Maputo Protocol, ratification that ensures accelerated entry into force of the AU Convention on Ending Violence Against Women, ensure that for Maputo Protocol, reservations are lifted, ensuring that those states that have not ratified, please, we make an urgent appeal for ratification. So I thank you all for your time. Thank you.
Thank you very much, Honorable Commissioner and Vice Chair of the African Commission for Human and People's Rights, who is also the Special Rapporteur on the rights of women, and leads oversees the implementation of the Maputo Protocol. And she begins with an aspect that is very important, decolonization of women's rights. Is this a reality? Is this thing that women accessing their rights is a foreign approach to women in Africa? Is this because at the core of the Maputo Protocol lies issue? Why is a particular aspect of violence, particular gender? What makes it applicable to only a particular gender? These are issues. And she has also given us ratifications with 46 countries ratified, and also noted that some ratifications and the need for continued advocacy. And she brought out the important role of traditional community leaders at this stage, given that a lot of issues are tied to exceptions, a lot of issues on protocol. And finally, political will and deployment of resources, aspects of budgeting, technical support, infrastructure. On the AU Convention on Ending Violence Against Women and Girls, this is an important convention because it is drawn out of core elements of the Maputo Protocol, and the fact that this is specific to violence issues underscores the importance of the issues of health. And so it's a, and we get a for traditional practices to emerging areas of violence, like humanitarian violence by conflict, by climate events and emergencies. Overall, here again, she calls for universal ratification of both instruments, levels through first and the role of the civil. Thank you very much for the Honorable Commissioner. Can we give her another round of applause, please? And of course, no less important, we are going to take the presentation of Honorable Commissioner Mutford Mwandenga, who is the chairperson of the working group on ecosystem. Going to speak to the African Charter on Human and Personal Rights on the rights. You have, Commissioner.
Thank you. I will try. Thank you, Madam Moderator. It's a pleasure for me to make a presentation on the protocol to the African Charter on the rights of the social security. First, to mention that this to social and social is very important, and it's nothing new. It covers literally all of us, which is why when we look at the protocol itself, one of the preambular paragraphs starts by saying, we, the members of the Union, affirm right to social as so it this social is a human rights. The preamble illustrates was developed an X of 2025 nutrition access. The protocol is a single instrument on the rights of the protocol to the African on human and people's rights and access to social services, e.g. education, nutrition, water, housing, shelter, and property. On the other hand, the social and social allowances, public and private measures, and private measures designed to protect individuals and families against income insecurity caused by contingencies, injury, maternity, sickness, old age, and death of a family member. So from these two definitions, it's possible for people to say social protection indeed cover literally all of us. And the definitions in the protocol itself. Now, the way the protocol is designed, it covers issues throughout. I shall the way the act the protocol itself has provisions that deal with the guiding for economies. There is also it also deals there is also sickness. There is also self. There is also the right to food, water, and there is also there are quite this particular protocol. On my part, in the manner it is designed of needs, but we heard from what the legal counsel said in terms of ratifications. Unfortunately, we don't think in that regard. This is notwithstanding the fact that the issues that are protocol are issues that affect all of us. Those in the corridors of power. So it is quite that despite we still any tangible movement. That's right. The legal counsel ratification. That is from what could be causing all of these problems. It seems to us as the commission that are a lot of issues which are impeding the ratification process. Mention has already been made about the fact that there is a seemingly lack of political will. That, I think, is a major problem. But when it is they came up with this particular document, any state, if I could, the foreign, the other lack of awareness is one of the challenges we work towards, so that at least people get to know about this. But I think there is availability of information, but it does seem as if a lot of people may not be interested in looking at some of these things. Maybe they are still in their comfort zones, so they don't think that at the moment it's necessary that they should look at this very important thing. But the other problem seems to be that there are misconceptions, which is that some believe that the protocol establishes new obligations. But as I mentioned from the preamble, we are talking about reaffirming that social protection is a human right. So it is something which they know, but for some reason or the other, I think they do not want to accept the fact that it is something that has to be taken into consideration. Then, in as far as we are concerned as the Commission, we have been trying as much as possible to take certain actions which can ensure that this protocol comes into fruition. Some of the things that we've been doing is to keep this idea of lack of awareness is that the Commission has been planning quite a number of activities such as panel discussions, seminars, workshops. We as a Commission have also been taking it upon ourselves to be urging states to sign and ratify the protocol during the reporting process as well as dialogues. We also take it upon ourselves to urge states to sign and ratify the protocol during our promotion missions to various countries. We also include recommendations in our concluding observations as well as our mission reports and activity reports. We also encourage the dissemination of the protocol to the various stakeholders in the various EU languages. Now, with respect to issues to do with financing, which I think sometimes is a major bottleneck, I would want to draw the attention of this August gathering that the protocol itself in Article 24 provides for financing. And when you read Article 24, that actually it does not place any personal responsibility on from the government officials, so much so that the issue of financing should not be an impediment. I would like to close by reading what Article 24 provides. It says, state parties shall develop and operationalize costed national plans for social protection to guarantee the provision of social services and benefits. B, take necessary measures to ensure the adequate funding of social protection systems, including through domestic funding, by allocating specific and transparent budget lines and taking into account contributory capacities of different population groups. Then C, develop flexible feasibility, costing, and sustainable funding strategies combining contributory and non-contributory funding modalities for nationally defined programs to ensure sufficient funding for social protection programs. Commit themselves to progressively allocate a minimum percentage, it says a minimum percentage of public resources to social protection expenditure, in particular expenditure that will ensure universal access. And then also ensure coordination and strengthening of development partner support for sustainable financing of social protection. The way it is designed is such that it doesn't place the onus on the individual government officials to fund these social protection schemes that are envisaged under the protocol. So it is my submission at the end that there is basically no need why financing should be held as an impediment in us ensuring that the protocol is ratified or signed. And in any event, like I said, at a certain point in time, maybe any of us may wish to benefit from the social protection and security that this protocol is meant to provide for. I would rest my submission, Madam Moderator, on this note. Thank you very much.
Thank you very much, Honorable Commissioner. He has spoken on a very critical instrument indeed. That is very important. And the social protection system that maybe may come up as a response to vulnerable situations, occasioned by certain contingencies, such as unemployment, displacement, and other unusual circumstances. And surprisingly, only 2 signatures and 2 ratifications were accorded this very important instrument. But surprisingly, many states are already implementing a social protection system. In practice, actually, I think it is set aside from the budget, from the normal budget, yes, the provisional budget to be able to do critical issues, and sometimes an emergency budget to be able to meet with a right situation. So it is surprising that there have been such few signatures and ratifications. And maybe he traced it to lack of political will or maybe lack of awareness of this instrument. Or could it be due to overlaps existing with other human rights-based instruments, causing maybe fatigue on states? But whatever it is, he says this, he proposes advocacy plans. As a matter of fact, the Commission has already engaged advocacy measures or engagements with state parties during constructive dialogues in the reporting processes. And he also recommends for interpretation of this instrument to the AU working languages, and that could maybe popularize it some more. Of course, the final submissions are the same. He calls for the need, he calls on state parties to ratify this important instrument, domesticate it and implement it at the national levels. Thank you very much, Honorable Commissioner, for this presentation. So can we put our hands together for him again? Thank you so much. And with that, we have come to the end of this presentation. We are going to receive, to entertain interventions from the floor. The fact is that we do not have too much time, and so we are going to be conscious of that. I'm assuming we will end at, in the next 10 minutes, and if we do that, we would have been late by 1 hour and 20 minutes. So let us be conscious of this, please. Do we have any interventions? Okay, so I have just been informed that because time is fast spent, we are going to break at this point and receive your interventions later in the day. We'll break and go out for lunch now. And so we have come to the end of that session. I would urge you to clap once again for the commissioners and to also clap for me. It is not easy moderating and regulating 5, 6 commissioners. It was not a very easy session for me. Good afternoon. Enjoy your lunch.
Merci, Madame la modératrice. Et je pense que les applaudissements que vous avez faits sont même maigres. Il faut plutôt, elle a passé du temps ici à s'arrêter et tout. On l'applaudit encore une énième fois. Alors, quelques dispositions logistiques. Le déjeuner, c'est au premier étage. Le SIDA, le restaurant, quand vous arrivez, vous allez sur la... Tout compte fait, les collègues vont vous accompagner. C'est sur la droite, je pense. Pour ceux qui sont sous prise en charge de l'Union africaine, il y a Madame Mélène. Là, il faut déposer vos cartes d'embarcation et puis, bon, la voir. Voilà, je pense que nous allons revenir à 14h et je vous souhaite bon appétit. Pour ceux qui sont arrivés de l'autre hôtel là-bas, n'oubliez pas que le check-in ici c'est à 14h, donc voilà, il faut essayer de voir. Bon appétit à vous et à...
Don't forget that the check-in here is at 2 as well, so do well to check in here. Thank you and see you at 2. We are returning at 2 p.m. 2 p.m. We'll resume work. Let's go for lunch. Let's go for lunch. For the other logistics arrangement, you can approach us for us to explain the details to you. Thank you once again. There's a coupon on the table here. Try. Mr. Tamaklo, please approach. Mr. Tamaklo is there at the entrance. Is at the gate, at the door. Kindly approach him for your lunch coupon. He's at the door. He's at the exits. He's at the exits. So kindly approach him for your lunch coupon. You can leave your personal items here. The hall is protected. It's safe to leave your personal items here.
Can you receive interpretation now? If there's anyone who is English interpretation,
English channel 1.
can you all hear me in all the languages? Sorry for the mishap. So as I was saying, we are going to fuse the 2-day meeting into a 1-day meeting. There have been some changes. We are going to try as much as possible to cover the most important. If you have a presentation for 7 minutes, please try and make it 2 minutes. That's the only way we are going to be able to achieve our objective. We are going to try to reduce our presentations from 7 minutes to 2 minutes. Moderators, please make sure that this is adhered to. Now, we are going to move directly to session 4, understanding the ratification process, how to overcome the low ratification rate. Moderator is Mr. Hervé Kouate, representative of UNHCR. Are you here, Mr. Hervé? Mr. Hervé, are you here? Please come to the podium. Please come to the podium, Mr. Hervé. Yes, thank you. You're going to lead session 4. Thank you so much. Over to you. How much time do we have for the panel? One. I think you have a maximum of 10 to 15 minutes. Co-panelists, please join me. Panelists, you already know yourselves. Just come directly to the podium. We don't have time to introduce you. Yes, go ahead, please. I'm based in Addis Ababa. I'm happy to be here. And I have the honor to moderate this panel. And we have 3 panelists. Professor Songora Odombana. I'm going to briefly introduce her. We have Madam Audrey Nana from Ghana, Ministry of Foreign Affairs, and Mr. Dosso Rodrigue, also from the Ministry of Foreign Affairs of Benin. Our panel is on the issue of the process of ratification. We have 2 questions. The first is, why must we ratify and how do we ratify? And so to respond to these questions, we have Professor Odombana, who is going to talk to us about the principles of international law on relationship between international law and internal law. And then she's going to give us some elements that can lead to difficulties or obstacles, and then she'll also make suggestions. Before giving the floor to Professor, I would just like to say that Professor Ndombana is a human rights professor. He is head of department of the Institution of Human Rights of Nigeria, and he is vice Deputy Professor to Ismail Mohammed Center for Human and People's Rights of the University of Venda in South Africa, among other titles. Professor
international law prefers over municipal law. Now, the most of municipal, which is derived from the Roman law, and the Anglophone, they are mostly monist. The Nigeria, there are others. These are the examples of monist. And whenever money, in other words, of ratification, international law automatically becomes part of the domestic law. And I'll just give an example of the Constitution of Angola. It provides duly approved or ratified international treaties and agreements shall come into force in the Angolan legal system after they have been officially published and have entered into force in the international legal system for as long as they are internationally binding upon the Angolan state. What this simply means that there is no requirement for an extra domestic enactment. Upon ratification, the treaty, whether it's a human rights treaty like the African Charter or any other, automatically becomes part of the domestic legal system. That's the meaning of incorporation. Now, on the other hand, there are states that practice what we call dualism. Dualism sees international law and municipal law as two parallel lines that do not meet because they have their own sources, mechanism for elaboration, and this other one have its own sources and own mechanism for elaboration. They can only recognize each other. And that process of recognition is what we call transformation. I've heard a lot of language of domestication. There is no such terminology in international law. The proper terminology is transformation. Monostates incorporate. Dualist countries transform. Transformation and domestication do not mean something. To domesticate means to turn. To transform means to change. So in transformation, we change the character of international law and into domestic law or municipal law. So for all practical purposes, that document is no longer an international treaty. It becomes a domestic enactment, even if the provisions are the same. But it becomes a domestic enactment subject to the principles and rules of domestic law, which has its own procedure for interpretation, its own procedure for enforcement and several others. That is for dualist countries. And it is derived from the common law principle of parliamentary supremacy, which is that the parliament is the normal lawmaking body in the municipal legal system, particularly for the common law countries. And so it would be a violation of the principle of separation of power for the executive, which is normally the treaty-making body, to go into the international conferences, elaborate and adopt treaties, and ratify it, and then it becomes law at the domestic level. That's a violation of the principle of separation of power. So the parliament must be involved after ratification to change that into domestic law. It's a process of just read of the no treaty between shall have because the national dualism. Okay, apart from that, there are apart from that ratification. It enters into force and does not require the process of and at the declaration interesting oh, thank you. So our next from Benin, Monsieur Dessous, je passe en français, Monsieur nous vient du Bénin, où il est directeur adjoint. Et parlant justement de ces questions, je pense que ça ligne dans un système que Dessous va nous présenter aujourd'hui, y compris dans leur expérience de la transposition en droit interne des instruments juridiques internationaux. Monsieur Dessous. Pour le panel. Je veux bien comprendre qu'on est pressé. Soit dire, on peut écouter s'il vous plaît.
Have three. That is authorized to sign and ratify international laws. It's the president. We have two levels of ratification. We have the government process, and then we have the parliamentary authorization process. Now, before moving to the governmental ratification process, I'd like to say that it may happen that a ratification requires constitutional revision. It could also happen that ratification of an international instrument needs modification of legislative documents. Now, in a framework of the human rights instruments of the African Union, I must say that the ACHPR is taken into account in Benin. Now, what happens at the governmental ratification process? The government has an interministerial committee presided by the Minister for Justice and Legislation. And then we have the Minister for International Affairs, and then other members. We also have the Director of Legal Affairs. We have the Ministry of Justice, among others. So this team prepares a document that we call draft law. That is the decree that the government needs to adopt on authorization for ratification by Parliament. Now, in this intergovernmental process, we verify the alignment of the text to our internal provisions. And when an international instrument has provisions that are contrary to our internal provisions, then we need to do the necessary amendments. Now, before we sign this into law, promulgate this into law, we need to ensure that we do the necessary amendments.
Un peu les formalités
Now, I would
nécessaires à
also like
l'entrée en
to
vigueur.
now
Alors, après le vote
explain the
de l'Assemblée
necessary
nationale,
processes
le chef de
for the
l'État
entry
prend
into
un
force.
second décret
Now,
portant ratification.
the
Et sur cette
president
base, les services compétents
makes a
du ministère des
decree
Affaires étrangères
on
établissent
ratification, and
les
then
instruments de
they
ratification et
establish the
la
leadership process to be done. Thank you. That's the process.
Thank you, Mr. Duzu, for education to also tell us the process of ratification in a monist system, with example from Benin, and the different relations the various agencies have. Now, I'll go straight to Madam Audrey Nana, who is from Ghana. She will share Ghana's experience. Nana, she is the director in charge of treaty at the Ministry of Foreign Affairs. She is the best person to speak on this issue, to share experience in the dualist context. Madam, you have the floor.
That is our executive. We need approval from our executive. Before you also have to engage the Office of the Attorney General to determine whether the legal obligations conflict with any internal or domestic legislation in Ghana, what exactly will be expected of us as a country in ratifying that convention. So sometimes maybe we have some reporting to do or something like that. So all those things will be determined. And it is important that you seek the opinion or legal opinion of the Office of the Attorney General before you go to the executive. Otherwise, it will not be accepted at the executive level. And when you are going to cabinet, you are indicating what decision is required. You are indicating what will be required of Ghana if we ratify the convention. You want cabinet to know whether it has any financial or legal implications, any form of impact, social, economic, whatever, but mostly financial or legal implications on Ghana. And then you give your final recommendation as to what we should do. After that, then we move to Parliament. So when Cabinet approves, we now move to Parliament to seek the approval. All of this is based on the articles in our 1992 Constitution. And so when it goes to Parliament, Parliament may do two things. Either they are ratifying by an act of Parliament, or it's being ratified by just a resolution of Parliament. And if it is an act of Parliament, then that one, it means after Cabinet gives approval, you need to send drafting instructions to our Attorney General. They need to put it in a law, go back to Cabinet for approval before you come to Parliament for the ratification. If it is by resolution, that one right from Cabinet once you have approval, and then you go to Parliament for ratification. And with all of this, supposing that the treaty, the implementation does not just rest with foreign affairs, then you need to engage all the other institutions that would have a mandate in the performance or implementation of that treaty. And here, because we are talking mostly about human rights treaties, it means it cuts across. We have for women, so gender, we have for Commission for Human Rights and Administrative Justice, we have for Office of the Attorney General. So by the time you are seeking all these approvals, you should have engaged all these institutions. They must be on the same page, and you must all be involved in the drafting of the memorandum that will go to Cabinet and to Parliament. If for any
reason any of these institutions have not been involved in the process, it can be, it can affect the whole cycle towards ratification. So in our case, it's quite complicated, it's quite difficult. It involves a multi-stakeholder and also actually involves some resources, because to make it faster, you may have to do workshops, you may have to engage them, for a couple of days, seek everybody's opinion before now you go on to seek the approvals that you need from cabinet and ratification and parliament. But after all that, then we get our ratification, then it comes back to foreign affairs, and then foreign affairs will go on to do the instrument of ratification for our president. He's the only one that can sign and seal, and then we have it deposited, in this case with the AU. Quite complicated, but we have tried to do it, and we promise to continue to do that. Thank you.
Thank you very much, Madam Nana. And with this, we conclude the panel. I would just want to share an experience from UNHCR on this issue of ratifications, just pointing at the fact that, and it's good that Madam Nana pointed that sometimes ratification may be impeded by the fact that beyond experts, people making the policy or the political decisions of ratification may not understand or may not even believe that the issue we want to address is actually an issue. And we are facing that in the area of nationality and statelessness, for instance. Very happy to understand, to listen to, about sensitization initiatives. It's very key. And a very, very important testimony to this can be the very quick pace of the Kampala Convention, where there is clear understanding that it is clear, it is an issue. Other conventions may address issues that are understood only by experts, which really makes it important to build this understanding. Thank you very much, my co-panelists, and so sorry to be very short indeed, and sorry to our very able master of ceremony. Sorry again. Thank you, and I yield the floor back to you.
Excellent. Merci beaucoup. Vous savez les membres de votre panel, et donc vous les appelez pour qu'ils viennent.
Discussions, and that will be moderated by Ambassador Jinaya Toure, Director of Legal and Consular Affairs of the Ministry of African Integration. Madam, you have the floor. Thank you so much, and thank you to all those who took the floor before me. Now we are going to continue. We've already set the scene. We're going to know what's working, what's not working. We know some challenges. We talked about mapping the ratifications of our instruments. Now we need solutions, we need recommendations, we need strategies. And so we're going to talk about the different actors concerned. And the next panel is quite representative of all the concerned stakeholders. So now I'd like to invite to the podium the Commissioner Solomon, if he's here, Banjul Commission, and then Commissioner Avel Gavar of the Committee on the Protection of Children, Honorable Amina, Mr. Kwate, ACHPR, Madame Amon Kiata, Morocco, I don't know if she's going to join us or not, and then we have Mr. Michael NGO. So we have the relevant stakeholders, and we've been told to make our session shorter. So please try to find a way out of this. We know that we need to come up with a holistic approach for the session. And as we said earlier on, our objective is to disseminate information. We want to know what these legal instruments are in order to ensure ratification We need to do our possible best. We need to we need to be able to work on the documents. The most important thing is the implementation. So what's the added value of these stakeholders? And we are going to know this from the different panelists during this session, because they're going to tell us about best practices in order to arrive at our objectives. Mr. Solomon is not here with us. Commissioner Avel Gava, you are here. Please share your experiences in the domain. Thank you so much.
But reflecting on the experience of the African Committee of Experts on the Rights and Welfare of the Child, I will share main aspects of our experience. And the points I want to discuss are follow-up consultations, leveraging ordinary sessions, and advocacy missions. The committee adopted an innovative approach to address, and so I'll be calling some countries not and observe the report as a, and so was an engagement, a follow-up consultation and with that country. The committee addressed of the state in Maseru of the committee and created space for constructive approach, dialogue, and this the presentation of the following year. The same with Kenya, and it also proved effective as the periodic report came in July 2025. And advocacy on ratification. Dedicated panel was convened with Somalia and Sahrawi Arab Republic. At this time, consider 3 of the 5 members that had not yet ratified the African Children's Charter. And the second, in the office of on the ratification process, explaining the steps. And so a draft parliamentary discussion, South Sudan, and tabled before the parliament in 2014, but cited conflict and other issues. Sahrawi Arab Republic also stressed the state's commitment to child rights as contained in their legal frameworks. This is in the cracks if this constructive dialogue had not been convened, and the committee would not have been seized of such information. And so following advocacy messages, and these countries responded accordingly, and especially with Somalia that filed this instrument, Sahrawi Arab Republic that's ratification the following year in 2024. Advocacy generally, the committee carries out advocacy on reporting, and it used the 45th ordinary session to address overdue reports from Central Arab Republic. And in this instance, UNICEF of support, technical support, and even financial support. So this underscores the role that AU and UN could come in to support the reporting processes. And this leveraged of some of the state parties that were already before the committee. And finally, on sorry, just a minute. On follow-up consultations, this is the ordinary mandate of the committee, and on implementation hearings, where it brings able to discuss at that level, inquiring into the causes, ratification, and hearing from the states and engaging and state parties to ratify. So we have about 4. This has proved to be a success story. Thank you.
Merci beaucoup.
The bodies of African Union, we have PAP, the Pan-African Parliament. And so this gives me the opportunity to give the floor to Honorable Anna Idris, who will talk about PAPs. Thank you, moderator. I'm taking the floor with a lot of pride and a sense of responsibility as a minister representing Chad to contribute to this fundamental issue on ratification and effective implementation of instruments protecting human rights at the continental level. I'd like to briefly talk about our role as PAP. The Pan-African Parliament plays a strategic role. We support and we catalyze actions in terms of the ratification and implementation of human rights instruments at the national levels. Even if it doesn't have binding, even if it's not binding, and we have promotion and awareness raising. PAP sensitizes national parliaments and governments on the importance of ratifying continental and international instruments such as the Charter of Human Rights, Human and People's Rights, the Charter on Democracy, among others that we mentioned this morning. We organize campaigns, conferences, and workshops to promote these instruments to citizens and to decision makers. We also play the role of political advocacy. We adopt documents and we encourage governments to ensure that they implement treaties on human rights. We also carry out monitoring and evaluation through our Permanent Committee on Human Rights, PAP, on the state of ratification and implementation of treaties in the member states. We work in synergy with the African Commission on Human and People's Rights and African Courts on Human Rights to encourage effective implementation. We also have capacity building of national parliaments. PAP serves as a platform for experience sharing among parliaments, national parliaments. We also support national parliaments in harmonizing legislations with regional and international instruments on human rights. And then finally, we have the rights of African citizens as a representative body of the African people. We serve as a channel between the people of the African Union and their leaders to ensure that their human rights are defended at the national levels. We also have create an advocacy space for CSOs and human rights defenders. And then finally, I can say that PAP doesn't ratify treaties, but we play a role, a huge role, in ensuring that member states are able to ratify human rights instruments and incorporate it into their national laws. However, we don't have the legislative power, and we don't have enough resources. Thank you. Thank you so much for your very clear and straightforward presentation. As you said, for the time being, PAP doesn't have a legislative role. You only play an advisory role. But in the meantime, you serve as a bridge between the African Union and its member states. You're playing a very excellent role. Now, we have other bodies that are also in charge of promoting human rights and model laws of the African Union. Now we are going to move to partners of international organizations, among which we have HCR. Mr. Elve is going to talk about his experiences in their domain. What is the role of these types of organizations? Thank you, Legal Counsel. As you said it very well, I'm going to share an experience, a practical experience with you. The issue of statelessness, and then talk about the African Union framework. This is a universal issue, and it is governed by two conventions, one of 1969 on the status of statelessness, and then the other one is 71. And then in recent years, we had a boom in the number of ratifications of these conventions, and in some minutes, I'm going to share experience on it. In 2014, HCR initiated an international campaign against statelessness. And in the framework of this campaign, we implemented an international plan of action on statelessness. And one of the points under this was the adoption of the Convention on Statelessness and its domestication. Now, in the framework of this international action plan, we encourage states to make sure they have national plans, national action plans. Most of the countries on the continent have a national action plan against statelessness. And one of the recurring points of this is ratification and domestication. I'm happy to say that in the framework of this plan of action, a country like Côte d'Ivoire, for example, has become the first African country not only to have ratified this convention, but adopted a legislation on the protection of stateless people, through which a person who doesn't have a nationality can come and go through a process established in the law and at least have access to rights just as a people of the state while they wait to have a nationality. So this is something that has been done. And I think we've had about a dozen ratifications in a number of years on the two instruments. So the theme of this session is about opportunities. And so I'd like to say that it's equally important to seize opportunities. I think in November, the Specialized Technical Committee of the African Union on the issue will meet. And on this issue of statelessness, is going to be taken into account. And this is to encourage countries to ratify the conventions and make it more visible. And I'd like to conclude by talking about the AU Legal Week. Maybe we could also involve partners, and once in a while we talk about about the instruments. Thank you. Thank you, Mr. Elve. Now we're moving to the states. The states, Madam Anne, maybe you can also share your experience in the domain. Thank you. I give you the floor.
People's rights, as well as it ratified the protocol on the Maputo Protocol on the rights of women in Africa. In this regard, Uganda has submitted so far 8 reports to the Commission on Human and People's Rights. In 2023. Uganda ratified the protocol on the African Charter on the rights of older persons, and we also ratified the protocol on the rights of persons with disabilities, and we did all that on 11th of February 2023. We were able to do that because we had stakeholders at the same time. Uganda ratified the OAU Convention on Refugees, internally displaced persons. The one in refugees was in 1987. And we were requested that we shall be able to report and in that I'm happy to report we have ratified the protocol to the African but I must of human rights instrument ratification. Process. We recognize costly, but also very time consuming. That said, to the process of ratification, in fact, I established what we call an interministerial committee on human rights. A committee that is made up of very many ministries, departments, and agencies that has been tasked with as well as implementing all the recommendations that come from the various regional and international treaty bodies. Uganda also has a cabinet subcommittee on human rights that provides political guidance on human rights matters, but also human rights in a rather timely manner. So we acknowledge and we are grateful for the support. We think that they need to be strengthened on the regional level. How do we make our system? Madam Moderator, allow me to provide 3 recommendations that we could consider. One is to the African Commission, because that gives us an opportunity to engage our state. 2 is Madam Moderator is for the office to provide us annually with a reminder of the instrument. 3 is support that for their ratification as well as implementation. 4 ratification the session with various legal systems, which makes it very challenging to have a uniform approach to some of these things. 5 for example, the UN has the UN Office for Human Rights that really supports treaty reporting, builds our capacity, but that they limit it purely to the conventions at the UN level. I wish we could do that for the African Union Convention. Madam,
is not only bearing the name Kampala, is one of the unique conventions. Uganda can actually be the shining star for this sort of legal instruments on the continent. Also, the Moroccan experience is not less. I'll now give the floor to Barry, who is from the Institute of Human Rights from Morocco. You have the floor, sir.
Independent institution entrusted with a large mandate of promoting and protecting human rights. I'm just going to go back to what was said earlier by Honorable Commissioner earlier on the effectiveness of human rights. Just to say that it was, the effectiveness is a common ground for our strategy for the last five years in Morocco. And this effectiveness as a principle requires, we think that requires to strengthen the legal foundations and institutional guarantees to protect and enhance effectiveness of human rights. And within this framework, we work to advocate for the ratification of Africa instruments. As an independent institution, in our annual report, and we are very persistent advising the government to ratify, and in our reports, they are each year they are addressed to the parliament, to the government, to the highest authorities in the country. But we explicitly recommend ratification. This is one point. The second point is develop memorandums, as their opinions also addressed to different stakeholders, just to establish and to present the legal and institutional arguments and opportunities on the benefits of the African instruments. But also, very important for us as an independent institution, as a national human rights institution, is to invest in awareness and in disseminating knowledge about the African system in Morocco. So we organize workshops, seminars, and training sessions, including also in collaborations with the EU bodies, as it was the case, as an example, like 2 years ago with the, I think it was the 7th African Forum on Transitional Justice, which was held in Rabat, Morocco. So we aim from these platforms to foster ownership of the African norms, but also to use them as references in their work. So, as I said, also we invite the honorable commissioners to Morocco to participate, but also to advocate for the ratification. We facilitate and advocacy meetings with the authorities in Morocco. So the last thing I'm going to talk about is also accelerating our work within the African National Human Rights Institution Network, the NANRI. So as an NHRI in collective advocacy efforts, as a wider adherence to African instruments, assistance in the continent on how best to support. But right now, I left back home our colleagues from Burkina Faso, and we will be hosting a couple of the upcoming weeks of trials to exchange practices, to talk also. I think, as the final word, I think the NHRs have a role to play in this, but they also need in advocacy and how to best use their means also to advocate and for the implementation. And thank you very much.
Merci beaucoup. Première idée, l'importance de la simulation, mais surtout de faire qu'est-ce qu'on peut faire d'instruments juridiques qui sont vivants.
From the family. We didn't talk about teaching human rights in our universities, master's program in human rights and international human rights and African rights. My personal experience at the University of Qatar, I had a first master's in the entire of Africa. That is solely dedicated to the African human rights. They go every day in a school to go and study about the African and human rights. So I have some colleagues who wrote a whole dissertation on just on the African right. That's that we have to change the doctrine. There should be a doctrine. There should be a movement. We should promote our legal instrument, the culture of human rights. I've just said that starts from the Ubuntu culture, the practices of African practices that are rooted in our tradition. We have to implement them, enforce them. We talk about the role of the media, CSOs. They are the gatekeepers on a continent where African countries, unfortunately, are not only behind in terms of implementation of human rights, they are sort of allergic to issues of human rights. So that's my opinion. So I think we have to raise a very high standard and ensure 100% ratification on the continent so that each one of us has to put in the work for us to do it. It's our role and our responsibility for us to achieve that. Thank you very much. Can we put our hands together for her again? Applause, louder applause for her for the first panel, for the panel that we just finished having. Whilst they are going back to their seats now, we are going to the session of question and answer, interactions to the first the panels that we just had, for us to have an idea of how the day is going to go on, because we are a bit confused. Your Excellency, you may have to join the high table. Ambassador Diana Toure, she's in charge of legal affairs from the Ministry of Regional Affairs from Senegal. She's Senegalese. She will be joined by Mr. Ali Abdou, thank you very much. Madam, before I hand over the floor to you, I just want to give an overview of the rest of the day. If you go through your agenda, you see sessions, tomorrow's sessions. For tomorrow, normally, sessions 7th and 8th will be merged. They'll be merged and then will be moderated by Honorable Commissioner Sassi. So we have a lot of speakers. We try to consult the speakers. Some of them accepted that some people can do the presentation on their behalf. So after this panel, we have to merge. We'll have some Q&A. After that, in your interventions, you should come out with recommendations that we are capturing, or that is being compiled by the secretary. So at the end of the day, we can have recommendations that we can read and then close the day. After the Q&A, you have 30 minutes, and then we'll go to the last panel. Then the recommendations, and I will draw the curtain on the day. That's what we are going to do for the rest of the day. Thank you. Thank you. Greetings to the High Commissioner, experts, ladies and gentlemen. I'm Ambassador Diana Toure Batile, from the Ministry of Foreign Affairs from Senegal. I have the honor to co-moderate with Dr. Ali this panel, in reality, which is sort of a summary so that we have give the floor to experts for them to be able to have their flow. We've listened a lot, we've learned a lot from each of the countries here in terms of ratification, the difference between the various systems, the realities from each country that makes it the level of ratification is not the same across the continent on some issues. So I think this is an opportunity for us to be able to, especially for the experts from the member states, to share their experience with us and to answer some of the questions and also make some recommendation what we can do for us to have the universal ratification, which is our overall objective. The states are committed, but the procedures are very different from each country. The commitment is not, that's the commitment, but we have to follow up with advocacy so that we expect the objective that we have. So I will allow my co-moderator to also have a bite on the issue before we go to the panel and ask the questions. Thank you very much. Over to you, co-moderator.
Think of Mr. Marcel Apobo, the regional director. He sent his regards. I'm very happy to see some familiar faces from countries, Western Africa region. We deal with them quite regularly and support them in fostering their engagement with the United Nations Human Rights Mechanism as well as the African Human Rights System. Because we couldn't speak in the earlier session, some of us, I think, will have a chance to speak. I'll not abuse my role as the moderator. So now we are opening the floor, focusing mainly on the last different stakeholders spoke. So now this is a time for you, those who couldn't speak, to make your recommendations, suggestions, concrete, around fostering ratification and implementation of the African Union human rights instruments. Commissioner Solomon, you couldn't speak also in the earlier session. I think we'll give you the first chance if you are ready to speak. The floor is open.
Est-ce qu'il y a une liste des intervenants ou on le fait spontanément?
Merci beaucoup.
Instruments in terms of human rights. As a country that is fully committed in that area. I want to make an general comments just to say that the issue of ratification sometimes is approached thinking that the member states do not have the will to make progress, but there's a problem in sense of information sharing, and often during negotiations of some of these instruments, some member states take certain positions, legitimate positions for the matter. Once the instrument is adopted, opportunities are seized without the opportunity for people to clarify the decisions of government. Last week, we received at the Ministry of Foreign Affairs in Benin an association of promoting human rights, particularly right of women. They came to the offices and they to come and carry on an advocacy for the convention that was adopted in February, and the elimination against discrimination, all form of discrimination against women and young girls. After the audience, I prepared a letter to be signed by the Ministry of Foreign Affairs to approach his counterpart. Something came to mind, and then I approached our mission others. Is that the commission the AU has not made available the fund when you have to get to the national level. We should have had a legal and it's a signed document. I've seen on the internet a document on the first page has a stamp, but it's not a full text, and that was on the internet. Whilst talking to our mission in others, there were some positions during the adoption of the test. You understand that it's a complex exercise, and then has to come back to the organ that's responsible to implementation of this information to fill up the gap in information to enable the government to be able to go through the process of ratification. So that's the general comments I want to put across. Thank you very much. Thank you so much for your contribution. There were some difficulties that the Commission have taken note availability of signed documents so that the processes can actually start. It's easier for me to speak in English. I'll speak in English.
Presentations even from the legal advisor of the AU. And I think that maybe some of the options that we should look at is, I don't know whether it's too late now, but since all the 9 treaties or protocols together are talking about in the same, is there a way of, I don't know if you have to go back to the council or I don't know the process, but once do the ratification en bloc so that we don't have to do it, for some of us, our countries, because of the way the process is, it means each one you have to explain, you have to say the obligations are and what we have to do. But if there's a way that we put everything together with some, then it's easier for us when we're going through the ratification process. And we know that when we take one action, it covers all of it. I don't know how complicated it will be in the individual countries, but those are some of the options. We could take advantage of having champions for especially the countries that have done the whole process for most of it to carry the message. Have a scorecard which also includes just also, and then we are doing some kind of peer assessment of each other and making sure that at least it's not reward you with anything juicy or anything, but at least there's some praise that comes to you once you take all the boxes into the treaties. And something that happens within the UN, especially around this time during the high-level week, they have these treaties, an opportunity to sign. So you could also, look at that model and replicate it for any high-level event. Have and intensified.
Very quickly.
Thank you very much. My name is Debbie Mojisola Kupalasi from Wellbeing Africa in South Africa. Yeah, I want to, from what we have heard since, we understand that one of the reasons why we don't have this, we have political will. So I'm thinking of, is it possible that we begin to think of information or strategy to the state parties rather than presenting it like as in compliance and obligation, kind of burdensome to the state parties. Then the second, which I also want to talk about is we see the Maputo Protocol is making a lot of progress. Is it possible that the Maputo Protocol, we could learn the lead from what is making the Maputo Protocol to work? And one of the reasons, which I can also attest to, because Wellbeing Africa also belongs to the to SOA, that is implementing the Maputo Protocol. So we have a lot of support from that, and the SOA coalition is made up of many organizations and NGOs. So is it possible, which is a coalition? So is it possible that even the other instruments could also be organized into a coalition, and they are being supported by the African Commission, from the Commission, when they are going to do the ratification mission, having support from them? I think that can also work. I'm asking if it's possible. Thank you very much.
Good afternoon. My name is I'm a member of parliament representing the good people of the Boyam and Karagul constituency in the Parliament of Ghana. And I chair the legal and constitutional. This morning I've listened to two key things this is concerned: ratification and implementation. I note that, but I haven't heard much about implementation. The many jurisdictions, it is not and so and implementing. I've attended many conferences, and the implementation becomes a huge problem. I would want going around to see countries to do, how they are implemented in those various countries. That for me is a map of where we are and where we want to get to. You can have a million and reduce the talk. Thank you.
Thank you. I think the last, the member of the head, when he also the pudding is in the eating, and if after all has been prepared and done, and if we don't actually eat, then there's no point. That's why in the morning I started by saying for us to be mindful of this enormous gap that exists between the promise of these instruments and the lived realities of many people on the African continent. And that needs to be therefore, the whole question of, how do we go about doing the implementation? And that obviously needs both the legal, technical, institutional of the pursuit of implementation. That obviously brings to the fore the key institutions, parliaments, of which you come from, sir, the judiciary, obviously, national human rights institutions, civil society organizations. These are, the institutions that are made, to which reference is made in Article 26 of the African Charter on Human and People's Rights already. But remember that implementation is a product not just of legal pronouncements and processes. It is also about basically political culture, human rights culture, and practice. So how do we go about bringing about human rights culture and practice? And that requires us to look beyond this state of institutions and actors. And that is where we need to have an understanding that sometimes we think that these are where we have to invest, and then we invest a lot here, and we forget other areas of policy action, such as investment, trade, finance, and so on and so forth. All institutions and policy processes that impact on human rights, including these ones, they affect health, they affect education, they affect housing, they affect employment, all of which are basically fundamental rights that we need to be conscious of. And we need also to build what we call constituencies for the defense of human rights. That is beyond and above civil society organizations, the organized rights. That is where, for example, creation of human rights awareness among the wider public comes into the picture. If you think about the example of Senegal, for example, that faced of its democracy, who are the ones who actually saved Senegal from that during in last year? Is it the Constitutional Council? Is it the Parliament? If you go to Parliament actually endorsed what President Macky Sall proposed. It is the young men, women, who put their lives and bodies on the line, refusing to submit to that regression. And therefore, social movements, trade unions, professional associations, these sectors of society matter to us a lot, and we often do not talk enough about them. We haven't established the kind of alliance and relationships that are critical to mobilize these sectors of society. Increasingly, we hear about the media, but where is the strategy for engaging the media? How many of these conversations get air in the media, for example? Where is the Ghanaian media here, if I may ask? So these are, I think, the kinds of things that we also need to bear in mind, because indeed culture, political culture, institutional culture matters a great deal for translating, these promises into the lived reality. Thank you very much.
Merci. Je tiens tout d'abord, je me présente, je suis ambassadeur Sarah Chawani Abidji, je suis directrice générale par intérim de l'Union africaine et des organisations régionales africaines au ministère des Affaires étrangères de la République tunisienne. Je tiens tout d'abord à remercier pour la qualité des débats qui ont eu aujourd'hui. C'était réellement constructif. J'ai quelques remarques par...
Especially, I would love to raise the issue on proliferation and complexity and amplification of legal frameworks or legal tests at the UN level, regional level, African level. What is the African Commission trying to do to take into consideration that? Because member states have fresher constraints, budgetary constraints, and even sometimes manpower for them to be able to be updated or to be updated with and able to rectify some legal tests. My second question is the opportunity of the regional legal framework on human rights. Today, the Legal Council did an excellent overview on the list of treaties that were signed, adopted, deposited, because there are some tests have not received, were not adopted by the member states. Can we talk about failure in that instance? Is there an opportunity for us to see and then review those tests and continue to carry out advocacy for those tests to be rectified? The next one is the implementation. And I want to I agree with what the MP from Ghana said, who is just sitting next to me, is on the opportunity and how can we actually implement what was the ones that were ratified. Which role can the Commission play to ensure that the ones that you've signed are actually implemented to enhance the capacity of member states to be able to implement what is already ratified on the African continent regarding human rights? Thank you.
I want to just rise with our honorable MP from Ghana. I would like to offer a practical solution because during my presentation I did indicate that at the African Commission on Human and People's Rights, as accountability body, the mechanism we have is so that the dialogue and do an evaluation of the legal legislative to implement. So the challenge is for the fact that, for example, under the Maputo Protocol, the level of reporting is very low. And I think because as I indicated during my presentation, the executive obligation will be a platform. But in case parliamentary, so that when Parliament ratifies, so maybe on the document that has been ratified, there's a provision that calls for state. You can ask them, when was the last time you reported? What is holding you from reporting? So that you are assisting the National Human Rights Institution. I would like to give to the honorable member to take back to the parliamentarians to see how we can also at the national level get some help in terms of accountability and implementation. With regard to ratification, honorable colleague from the Minister of Justice and made an analogy with the UN system. Frequently said that the UN system has, they are present in all of our countries. So you have the UNDPs, UN Women, all over, and they, on the ground, they monitor on the ground. But unfortunately, the African Human Rights Mechanism is not present in all the countries. But we rely on the Permanent Representative Council, a committee member. So a permanent representative in Addis is development. So that's what you find that there's always a link between what is Addis transmission at the national level. So this is work on, and we all experience it. We cannot sometimes do directly with the state. We listen it. After a while, we don't get any feedback. So we have to actually listen into the arena and reach out to somebody at the national level. So these are so the permanent representative should be more proactive Well, we're not saying they're not doing their work, but they should be more proactive in ensuring that the information filters, that they're not aware of the instrument. In my advocacy, I think in my interaction with the legal counsel, before a letter was sent, legal counsel, correct me if I'm wrong, to all the permanent reps to say, this is the margins of the you use these high-level things. But when they from the capital, they were not aware. So we had to actually sit and explain to them again. So that also, we need to work on that. How do we ensure that the pipe, the conduit pipe, the transmission channels are not clogged, so things filter in at the national level? And maybe legal counsel, just to listen beyond also sending it to the panel representative, it might be onerous, but depending on the thematic area, maybe to the ministry copy. And if you're not breaching protocol, of course, because sometimes it's directly send it to us. And connection and the phone, so that we unclog the bottlenecks. But really, efforts are being made to make sure that in that respect, another parliamentarian from Ghana to say, Ghana is and I'm sure there are so many countries here. So deal with one issue on that we can at least the dialogue of this of the advocacy and implementation. Admitted by my colleague, Honorable Commissioner, it's very fundamental because otherwise it becomes an aspiration and reflect the lived realities of the citizen. Thank you very much. Thank you, Commissioner.
Yeah, thank you very much. My name is Joseph. I'm the Executive Human Rights Reporters Ghana, and I also Ghana CSO SD. We are looking at ratification. I think these are two big elephants. Why am I saying that? Ghana has a lot of convention, a lot of them, a lot of treaties. I think a lot of processes ought to be followed. But if you also implementation, big thing. Now, we have rushed things, getting a lot of this implementation is a bigger problem which we haven't dealt with. And if we are talking about African Charter on Human and People's Rights, ratify one, are we looking at problem that we need to deal with? I think the international community has over the years. That is sort of that can drive them. Well, we'll be able to drive them if we are able to incentivize. But the biggest issue, I'll leave it here. Thank you.
Thank you so much. Yeah, we are being told that we need to wind up. But quickly, maybe to share my reflections, because I couldn't speak in the previous session. From the perspective of the Office of the High Commissioner for Human Rights, I mean, United Nations and Africa Union cooperation. My fellow UN colleague from UNHCR shared his experience also. I can say we are also in collaboration with the United Nations country teams. We are actually dedicating a lot of effort, energy to foster implementation on the ground, implementation of outcomes of human rights mechanisms, including from the African human rights system, by the way, increasingly. When we support also reporting exercise, the colleagues in this room from different countries can attest to that. We are actually, the African human rights instruments are part and parcel of our package. Although we have much more developed training package from the other instruments. And whenever possible, we send communication to the Secretariat of the African Commission, to the African Committee also, and they send us sometimes people also. So we are doing our best, because it will not help, honestly. A fragmented approach will not take us where we want to go. And having said that, mechanism to mechanism, I know also you are trying to move actually, a lot in this respect also. Including, for example, during the Universal Periodic Review, now the African Commission is making a submission, a stakeholder submission to the review of different countries, which is an excellent precedence. I mean, that needs to be replicated. So there is an engagement. So the African Commission is conveying its priorities in relation to the country under review. And member states are taking that into account and reflecting it in a recommendation. And as you very well know, the Universal Periodic Review has triggered a number of actions, including ratification across various countries. So this is one tool also. So for implementation, one maybe national actor, which I want to emphasize, and I know tomorrow is also more about implementation, so we can come back to, is the role of the national mechanisms for implementation, reporting, and follow-up. They go by different names in different countries, as you know. In some countries, they are called interministerial committees. You have different names, but we call them more formally in the national mechanism reporting and follow-up. We have systems trying to support this actually government, which coordinates nationally the engagement with human rights mechanisms, UN as well as African Union, and this is like, the call has been to make them permanent instead of ad hoc. Ad hoc approach has actually led to dispersal of drafting committees after the submission of reports, waste of resource, duplication. So now many countries have actually accepted this and have stronger systems in place, but it's a work in progress. I think we will continue to have this conversation with the secretariats of the African Human Rights Commission and others. We need to find a way of working together on this also, and strengthening these institutions at country level. They play a very key role. As members of these national mechanisms for implementation in the reporting and follow-up, you have ministries of planning, finance, education, health. So it's so diverse. And then we have also parliamentarians engaging with them, because these mechanisms need to have 4 key capacities. It's as part of the guidance we provided as ACHPR. Key capacities to engage, coordinate with state actors like parliament, judiciary. They need to consult with NHRIs and CSOs, and they need to have information management capacity, which is like tracking the implementation of recommendations or decisions from human rights mechanisms. So we are accompanying various countries on the ground to take to the ground the implementation of the recommendations they received from multiple human rights organs, United Nations and African Union. Somebody mentioned the proliferation of, instruments, the reporting fatigue also, the reporting burden. And we have not, again also, failed to take action in this regard. We are actually systematically taking steps. At mechanisms level, we know what the African and human rights organs and the United Nations mechanisms are doing, but at secretariat level, we are also doing our best to elevate the burden on member states, including through the deployment of technology. For example, we have national recommendations for tracking database, NRTDs, national recommendations tracking database. What they are doing is, in many countries, which we helped avail, like for example in Kenya, even in Ethiopia now they have it, but they need to operationalize it. It will put in one place recommendations from all human rights mechanisms, and it's actually managed by the coordinator of the human rights engagement in the country, and data is entered by the various line ministries. So it will really, make life very, very easy. So we have all these tools I wanted to speak, but there is a lot to do, including from the African Union human rights organ side. We need to join hands in enhancing these mechanisms. So we need to be creatively supporting member states. Otherwise, yeah, we're doing that. Thank you. No, yes, I don't want to abuse our role. Thank you so much, the MEC, and we'll leave it as it. Thank you everyone for your contributions.
Il y a eu beaucoup de questions et beaucoup de propositions. Nous remercions chacun. Nous en avons pris bonne note. Malheureusement, nous n'avons pas le temps de développer.
To details. Unfortunately, there's no time, and the recommendations are well noted. I just want to note that there's a major challenge that has to do with coordination from the government. It's very important. Somebody spoke about it this morning. I think it was the madam talking about the commitment, so that the leaders who actually be the promoters of these commitments, for instance, in Senegal, the ratification and the non-ratification of some of the treaty does not mean that we are not committed politically, but is linked to the administrative challenges and the bottlenecks between the ministry and departments and agencies. That does not also question the responsibility and commitment of other member states vis-a-vis their treaties. Thank you once again, and to allow other people to also take the floor. Thank you, Excellency. Thank you. Let's put our hands together for them for this session on question and answers. Whilst they go back to their seats, I would wish to invite Honorable Commissioner Sassi Safer for her to moderate on the panel that will respond to the question of the Honorable MP who spoke about implementation. This panel will focus on implementation, which is the second aspect of this activity. Honorable Commissioner, you have the floor. Whilst she sits down and invite the panelists, we have an hour. We have an hour for us, 1 hour to 10 minutes. There are 11 speakers or panelists. Someone had left these gadgets at the restaurant where we had lunch. And the program is moving closing ceremony is planned for tomorrow at 9. We are planning for the information I just received indicates that the closing ceremony is for tomorrow at 9 a.m. Commissioner, you have the floor. Thank you very much, Mr. Bruno. As you reminded us very well, this second segment of the program will focus on implementation, as our colleague from the Parliament of Ghana draw our attention to it. It's implementation now. It's time for implementation. We have discussions on implementation. As you might notice, ladies and gentlemen, we are going to fuse the two sessions, the 7th session and the 8th session. I will invite the panelists for the 7th session. I'm inviting Dr. Tariza Mutangi. Dr. Tariza Mutangi. Mr. Claudio Max from Mozambique. Mr. Michael Janyanko. Mr. Michael Janyanko, representing the Republic of Ghana. The rep from Ghana, Mr. Mike Janyanko. Mr. Karukai Rasoka from Zambia, sorry. Madam Karukai Zakokai from Zimbabwe, rather Zimbabwe. Seventh session will be dedicated to a presentation or focus on the second part of this conference, which has to do with implementation and effectiveness. We are going to have discussion during the panel on the implementation by member states through the national mechanisms and ultranational, national, and two types of instruments. Not only the various treaties and protocols that we've presented throughout the day, but also resolutions and recommendations and decisions from the African Commission for Human and People's Rights, the rights of implementation and the practical challenges and the bottlenecks. We also share the best practices from other member states for some of the instruments. Some of the instruments, I must confess, that are well implemented. So to show that we can make progress. Without much ado, I will start by giving the floor to Dr. Tarusa Mutange from the University of Zimbabwe for the presentation in 5 minutes.
Mbana, who spoke earlier on to tease out some of the issues that probably would have spoken about the monism, dualism debate. I think he has given us a good summary about that. My role here is to explore judicial incorporation as a pathway for implementation of AU human rights treaties. Or the opportunities. I hope I'll go as far as that. So just as a matter of definition, when you talk about judicial incorporation, you are looking at the court becoming a pathway of domestication of international law, treaties and decisions. So law through the court. Let me just give a footnote to say that usually national courts are quite protective of their national jurisdiction to some degree. And you definitely need to convince them that a particular treaty ratified by your country can be brought before them for adjudication of a particular dispute that has occurred in that country. But the purpose of incorporation or as a pathway for implementation of treaties and domestic law so that one can shape the other. It's a two-way communication, it's a two-way traffic. National courts, pathway through which treaties are received at national level, but also international courts bodies must also, even from some interpretation that comes from national courts, and we've seen that happening in the jurisprudence of the court, of the courts that we have. So what we have seen, there are basically two methods through which national courts become a conduit or a pathway. Number one, it is through interpretation. So national courts have over the years accepted that international law can be utilized as a tool for interpretation of domestic law. So what they are simply doing is to give a meaning to a national provision, maybe in the Constitution, and they are relying on international law, especially the jurisprudence of other bodies that have interpreted a similar provision. So, for instance, a national court is dealing with the right to health. For them to give a full meaning of that at the national level, a national court would like to rely on international law, more importantly, also interpretation of by institutions, national law, to give those interpretations. Look, for instance, the African Court, African Commission, and so forth and so on, or general comments which are developed by these bodies. They are a good source of the normative content of the rights, and that is also found in the national framework. But over the years, we have seen that even through interpretation, a national judge doesn't want to go beyond that. A national judge would not want to accept, in many cases, that an international instrument ratified can be used as a basis for before a national court. So that is method number two, which is called justification. So the question is, would a national court accept a particular right of freedom exists but has not been domesticated or made part and parcel of national law? That has been a question for over a period of time. We have moved as a continent from a position where our constitution national law. But over time, they said national law. For instance, national law, but that's association further. So they may make a claim to say the law ratified is part and parcel of this particular country, and so forth and so on. But you know that before certain national processes have been taken into account, like publication, immunism, or proper legislative incorporation in dualist countries, a national judge is very unlikely to allow you to come before him or her and accept that a particular right exists in international law, but not necessarily in national law. But other constitutions have the concept that they have given a status, a national status in treaties, to say treaties that have been ratified are part and parcel of domestic law, and they form part of the domestic legal system. Then, that's a third, that's a bit of status, national treaties and conventions. I would assume a national judge would be much willing to accept that you can come before them and assert a right which exists in a nation. That way, we can say that now a ratified treaty is being implemented through the courts. So what needs to be done in one sentence, what needs to be done, number one, is to always remind our national courts that they are part of the international. They are a conduit, they are a pathway through which national law becomes part and parcel of national law, so that they don't have an out here to advocate that our national institutions complete take their legislative version of international law to ensure that it can be asserted before national courts. Thank you, moderator.
Merci beaucoup. Merci beaucoup à notre intervenant. Merci beaucoup, Dr Tarizaï Moutangi, d'avoir mis en lumière le rôle des juridictions nationales justement dans la mise en œuvre des nombreux traités internationaux et les protocoles de l'Union africaine sur la protection des droits humains sur le continent. Sans trop tarder, je vais passer directement la parole à M. Claudio Maté du Mozambique. Oui. Vous avez la parole pour 5 minutes.
Thank you, Madam Moderator, to give the floor, but I'll speak in Portuguese, if you allow me. Ok, obrigado. Excelências.
I'm from Mozambique. I would like to talk of. It's not loud enough. It's on the implementation of. We can't hear. And all the conditionalities that go with the internal. Because our laws. No, it's not. Espera aí. Wait, speak. Espera aí. Espera só. Se ele falar para o micro, let him talk closer to the mic. Yeah, I can't get him very well. Yeah. The second place, I would like to. Oh, can you hear that? It's not coming clear. I don't know why. Try to speak again because. Yeah, sim, pode falar, mas o som não está saindo claro. Sim, pode começar de novo. Yeah. I was saying that in Mozambique, we have a constitution which has conditionalities about the ratification of laws, and that the constitution establishes that the laws that come in are made original to the state, and that there are some articles that give fundamental human rights to international laws. Provided they are in accordance with the International Declaration of Laws and and uh, because well, provided that the laws have their foundation in the African Charter of laws of the African. The laws have to pass through the National Assembly of the Republic, and that have to be adopted, and it has to go to the ministers so that, and that have to be ratified by the country. And any international laws that deal with fundamental rights is accepted by the state. And all the in relation to the international laws, Mozambique has
dos quais só faltam 3 instrumentos extremamente importantes para Moçambique, que é o relativo ao direito nacional dado, que é a educação da patentia. O segundo é relativo ao direito dos cidadãos e proteção civil social.
But it's not coming clear.
Violence against women has been ratified. This done, like the director of human, minister of justice, and I have the responsibility to revise, to have a periodic revision of our laws with the leaders and leaders, and we have the obligation to present a report to the governor between now 29th November 2026. This has to do with the ratification of different instruments that have been proposed. We also carry on monitoring of the implementation and ratification of these protocols. However, talking about implementation, we have a lot of problems, obstacles, because once the ratification is done, implementation becomes a problem. Ratification has to do a lot of political interference. We have laws, we have to license. How to disseminate instruments is very important so that people will be able to accept and understand the dissemination of protocols. Legally, we have a different. We have an interministerial committee in charge of human human rights, responsible for to help the Ghana, the adoption of legislation, and then emphasize the implementation of laws. And we have the fundamental law in fundamental law. We adopted a policy to implement a Kampala Convention. This has to do with the protection of children and women. Mozambique also patronizes, is going to harmonize to all the laws which have to do with human rights at the international and the local level. We also help parties. This is the development. This is the development that is happening between us and the government, and these are the kind of measures we have adopted up to today. Thank you. Thank you.
the experience from Mozambique with us and the procedures on how to rectify international instruments in your internally and then to domesticate these ones in your country. Also, the implementation to implement the institutions who are also in charge of this. And at the end of your presentation, you said that Mozambique has a strategy to implement, and I hope in the coming days we have more time so that you can throw more light on these best practices with other members. Say thank you once again, Mr. Claudio. Now I'll give the floor to Mr. Michael Jan Nyakon from the Institute of Human Rights in Ghana. Over to you, Mr.
I think for those of us who it has become sometimes very, at least, without the necessity to actually implement the obligations. And for us, perhaps domestication of concretizing that commitment and ensuring that the international legal obligations actually find expression in the national legal system. Even in money, particularly, international law is supposed to be directly applicable. The state actors often find some academics will call avoidance or contestation tactics to actually avoid implementing these obligations. Perhaps national courts are not the only ones who implement international obligations. All state actors are in some way involved in implementing international obligations, so that to the Ministry of Social Development, for instance, and say, I am entitled to social security because the state has ratified the protocol on social security. They would have to find some national legislation they would base their conduct. So it's a system. There's a theoretical expectation that international law is incorporated into the domestic legal system to avoid these state actors using avoidance or contestation that in the international obligations are expressly used into the domestic legal system, that those obligations are clearly set out. I think we find dualist system because so you find, for instance, here in Ghana, where both the ECOWAS court and the African court has been resisted by national courts, right? NGOs and other actors have tried to implement ECOWAS court decisions, African court decisions here. Have simply said no, we are not going to implement them because the treaties have not been domesticated. So it's vitally important that beyond the ratification to the relevant, in the regional organization, the African Union, that commitment is concretized by this final act of actually translating them into national legislation. I think South Africa perhaps does this quite well in a number of instances where when they adopt treaties that domesticate specific, let's say, treaty laws that are supposed to domesticate specific treaties, they indicate in the preamble that this law is being adopted to implement the obligations that we have undertaken under these treaties, so that there's no confusion, there is no a way in which you can avoid or you can contest, because international law in saying that other actors are trying to impose values or obligations that they have not accepted within their national legal systems. So those are the brief remarks that I wanted to make. I know time is against us, but just to highlight that absolutely it's non-negotiable that if we want implementation to become something states
as part of their regular, state activities, then those treaties must find a municipal legal system. Thank you.
Merci beaucoup, Monsieur Yanko, pour la clarté de vos propos, pour avoir respecté le temps imparti.
Dos tratados estrangeiros no país. Então, vamos para o representante do Ghana para fazer a sua apresentação. Ghana.
A rep from Ghana. I'll give the floor to. No? I will now give the floor to Madam Karukai from Zimbabwe for your statements. Over to you, Madam.
Both of them it is right. We have a dualist through an act of parliament. However, we have very progressive section, the opportunities for implementation, like section and we have the advantage of our current constitution, which has an expanded Bill of Rights. Some can't, such as, and we've already done away with the death penalty, the right to dignity, the rights to fair trial, and therefore that is. There's a broad mandate to monitor civil society, vibrant civil society, limited, maybe currently sort of private PVO Act or the Private Voluntary Organizations Act, which was government to play an oversight role. However, I think what has been talked about already about lack of enabling political, economic, and social, the culture of human rights, the culture of observance of human rights has grown greatly, so that the people enjoy the rights. The awareness do not even know about this treaty.
an economy which has not been well for some time. We still have suffering from lack of adequate financial resources as well as manpower resources. Also have cultural practices in the way of persistent child marriages, religious violate rights, and because at times they politically align themselves correctly and they are left like that, that is an element of impunity. So the challenges go on, but the opportunities are there. Thank you.
Nous vous remercions, Madame
Karukai, for your brief presentation. You recall your presentation, the system, dualist system of the Republic of Zimbabwe. You also threw more light on what you've done that you consider to be positive that was done by the government of Zimbabwe. And you also mentioned some challenges that you face that is impeding the ratification and, for that matter, human rights in your country. Now I'll give the floor to Mr. Edmond. Mr. Edmond Amakawi, fully from the Commission. Mr. You have the floor for 5 minutes. Before giving the floor to you, I simply want to call Madame Mapodisi Chivuko Titos from Botswana, who I didn't call her to join the panel. If she's here, is she here? Please, whilst we finish there, can we come up stage? Can we come up stage, madam? You have the floor.
Through the enforcement. Against me. This was a 2019 case in which the ECOWAS court gave its judgment in 2021. It concerned, at the end of the court proceedings, about $114 US. Niger paid 50. At least, to say this, one individual's life is changed. Second story, a case of women against violence and exploitation is waived against. This was a case in which pregnant girls from going to school. The ECOWAS court again gave its decision in 2019 and struck down this ban as violation. By March, Sierra Leone had changed that policy ban. Third story, there is a young girl, let's call her TFA, Cameroon. The government of Cameroon found itself. TFA brutally raped by a very prominent government official. So he was not facing justice. The Committee of Experts on the Rights and Welfare of the Child found at the end of the decision, Cameroon was taking its own. But in 2021, during COVID, the committee invoked one procedure that was used for the first time, implementation hearing. So this is the treaty getting in, and of course, with the applicant Netherlands brought Cameroon back to come and explain what it had done as far as implementation is concerned. Cameroon came, said that TFA had, but they hadn't done a lot when it came to the prosecution. Sometime later, they said the perpetrator had been prosecuted. What have you done to actually implement treaty obligations? One way, when we come before in November, ask us, which includes some of, and then also some of us on our activities. So I recommend it should persist.
Monsieur, intervention très parlante et très vivante parce que vous
some background with us that shows that the impacts of these treaties that we adopt on people's life. And your last recommendation is one noted by the Secretariat. Once again, thank you. So now we'll go to Madam Mapodisite Bogotis Botswana. You have the floor for 5 minutes.
We engagement, intervention with her. We had hope. So bring to all of us. I want to in your country, you are doing well, and you just need to up the standard a little bit. I want to, at the end of after you should be able to see that to have and also to domestication implementation. Right. So because we have ratified translation and ratification. That is the same for the United Nations and core human rights. And, what are the mechanisms in place of our obligations?
So, coordination of ratification and reporting to treaty bodies is a ministries and are you would find convention is allocated to the Ministry of Law. The same would happen to the AU protocol on the right and left, one ministry. Then the Ministry of they will take the Maputo protocol. That is what in terms, because reduces the, if all this of national monitoring body, it will be a lot. Therefore, within the ministries, we find departments, audit departments, and internal monitoring of the mandates. The internal controls, they ensure that are carried out. Then we have a dedicated mandate now to all this and so forth. Then we have an interministerial committee on treaties, conventions, and was established in 2022, and the secretariat is the Ministry of National Affairs. Every ministry that or to ratify would pass through the Attorney General's chambers. Also, national so in that committee we have the media, the civil society, we have the business sector, organization, you know, that you don't have a certain, or you have not done a certain, there's no sharing of information. So at that, there are comments, and also that they have the responsibility to do also the shadow responsibility in promoting and protecting human rights. So with all this mechanism, Botswana continues to improve her ratification rate, and the most, as we have said, is the Maputo Protocol. Another thing is that it has helped to increase the treaty reporting rate for Botswana. UN reporting status. We to the African Union on the rights and welfare of the child in 2023, and in 2025 in October we'll be reporting on the ACHPR. Therefore, I'm concluding. The lesson, the encouragement from Commissioner Jane when she their team to encourage us to ratify the Maputo Protocol. The lesson which they gave us is that we have ratified the UN conventions, but it's the same in the AU conventions. So the same to the African Union. Therefore, there's no reason why we should convention at the UN and not ratify at the AU. So that is the encouragement that we would like to give to us, so that when we go back, we look at which UN ones have ratified, so that they are equivalent at the African Union. Thank you.
Thank you. Merci beaucoup, madame. Merci beaucoup. Je vous remercie surtout d'avoir partagé une histoire de réussite pour cette note d'optimisme, pour dire que la mise en œuvre n'est pas forcément inachevée et incomplète, et surtout d'avoir
were used by Botswana, and also you stress on the necessity of stakeholder engagement and involvement of all society in the implementation of some of these instruments. Ladies and gentlemen, we'll come to the end of this seventh panel. Thank you all for the panelists, and I will ask them to give the floor to the next panel. Thank you once again. For the next session, I'm inviting Madam Felicitas Joseph from the African Commission on Human and People's Rights. Madam Felicitas, who was with us. I'm also inviting Mr. Brian Kiburango. Mr. Brian Kiburango. Mr. Brian Kiburango. Mr. Folosho. Mr. Folosho. Madam Sifiwe Malo from Eswatini. Professor Solomon Ebuka from the University of Nigeria. So Professor Solomon Ebura. Dr. Antoine Landry Bolongo Alumbe from Cameroon. And finally, and Mr. Marcel Kwadjo from Côte d'Ivoire. Mr. Marcel Kwadjo from Côte d'Ivoire. Do we have enough space on the podium? Do you have enough space? Are there seats enough on the podium? Ladies and gentlemen, panelists, this is the 8th session. We are going to have discussions on strategies to ensure proper implementation and protocol, and also its own decision, its own recommendation, so that I'll give the floor to Madam Felicitas Joseph, who represents the African Commission on Human and People's Rights. Madam, you have the floor for 5 minutes.
Seventh, 78th ordinary session of the Commission, whose objective were to develop a strategy for checking the status of the implementation of the recommendations internally and externally, and to develop a strategy for enhancing the implementation of the Commission's recommendation. The progress of the implementation project, which the project comes from this as an implementation of the concept note. The implementation project is comprehensive, covering both promotional and the protection mandate of the Commission. And so for operational purposes, it is divided into 2 components, namely recommendations on communication and recommendations from other working methods of the Commission. now I look at the first strategy, which is a strategy for checking the status of implementation of the Commission's recommendations internally and externally, which wants to look at the, which wants to address the baseline information, lack of database of recommendations, lack of reliable and efficient means of engagement between the state parties and the Commission regarding follow-up of the implementation of the Commission's recommendations. So far, the Commission has developed a manual and electronic database of the recommendations of the Commission, and the compilation of the recommendation are from 1981 to 2024 December, which shows that a total of number of 189 missions have been conducted in 49 countries, giving rise to 2,749 recommendations on different thematic areas. Secondly, there's a development of a manual and electronic database for state parties focal persons. The Commission requested member states to person of national focal points for purposes of smooth information and communication between the Commission and member states. Fortunately, very few countries, actually 4, have so far sent in their names, and we want to have the database of the focal persons so as to be able to follow up on implementation of the Commission's recommendations. And thirdly, the Commission have conducted a baseline study and report of the status of ACHPR decisions emanating from the communications. Unfortunately, we will not be able to go through it because of time. And we have a chart showing the status of recommendations from 1987 to 2024, as you can show in the screen, and also recommendations thematically. And on the second strategy, enhancing the implementation of the Commission's recommendations, the objective of the strategy is to address the implementation mechanisms and inadequate financial resources and allegedly vague and non-specific recommendations. The progress towards this strategy is that establishment of implementation unit has been made by the Commission in 2024, and currently there are 2 staff, which are both non-AU personnel, and they are addressing the gap in dedicated implementation monitoring because there was no dedicated unit dealing with implementation. And this creates an opportunity for external funding and operationalization, and also internally from the member states. And it also supports ACHPR's compliance and follow-up efforts. Secondly, on internal working tools, the Commission has existing working tools which have been improved so far. We have improved the communication manual, which is guiding legal unit on the processing of communications, so that you can have clear ways and smooth processing of the communications. We have developed guiding notes and drafting templates. And we're also looking at updating the 2020 rules of procedure to align with current developments and changes that are happening in the Commission in terms of the implementation unit project and working tools. The Commission will undertake the following interventions, that is comparative analysis of the level of implementation. And I forgot to say that so far the Commission has also finalized a baseline report because there was no data, there was no baseline information on the status of communications, how many have been decided upon, finalized, and we will have an opportunity to present it in the next session. And we will publish a trends analysis report and introduce digital dashboard and compliance scorecards and annual hearing to monitor state obligations and promote transparency. We also provide technical support and promote peer learning platforms to assist states to fulfill their human rights commitments and publish annual implementation reviews and convening compliance hearings. We also engage in direct dialogue with state parties and AU police organs to encourage timely and comprehensive implementation and publish the Commission's recommendations as per the database. So lastly, in conclusion, the Commission is ongoing project. The Commission's ongoing project is to enhance monitoring, follow-up, and tracking of compliance by states. Is a significant milestone. And those efforts to contribute to socializing a mechanism for compliance tracking engagement with states, and it is in the 2026-2027 strategic plan of the Commission. Thank you so much.
Merci. Merci beaucoup, Madame Felicitas, pour avoir partagé avec nous le plan d'action et la stratégie suivie par la
on human and people's rights for the implementation for not only the various international treaties but also its own recommendations and decisions. You also highlight and make a call to member states for them to be able to share the data and the various information with the Commission, and so we count on their usual cooperation. Now I'll move to the other panelists. This time around, they are going to have discussions on various actors, not only the states, but other important stakeholders for the facilitation of the implementation of recommendations and decisions from the Commission on other international treaties. Now, much ado, I will give the floor to Mr. Brian Pikirango from UNHCR. You have the floor for 5 minutes.
Of what I would call a philosophical reframing of our approach to implementation. And this, for me, are first principles that I think, in my view, and I believe we think collectively, that the principle of human rights on for the adjudication, including the Commission, are clearly the state. We negotiate these instruments, and we can assume that really then they believe in them so much bodies think that they need support, and that when a body like the African Commission issues a decision, we only have to work with that state that has meet. So the recommendation then from me is that we need to transform the punitive process, collaborative construction that genuinely improves. So we must treat well and implement continuously. We must emphasize principally potential to protect the Commission. We must focus on human dignity. And on this note, I would like also to speak to the issue that is usually cited as the major challenge to implementation, which is political will. Political will for me is a person, and for far too long, the success of implementation relies on who we have in the institution. When we have my colleague from Ghana, Mr. Edmond, for example, with that kind of attitude, then you're likely to have implementation succeed. A person with an opposite attitude, implementation is a challenge. I would argue for advocating for institutional so-called political will, such that implementation is institutional than individual, because individuals may either for cowardice, maybe where they feel that if I don't annoy the state by implementing especially contentious decisions, promoted, for example. I therefore propose, secondly, that engage with active state. For me, implementation of decisions can be affected by us in a way. We always are calling for coordination, national coordination mechanisms on implementation, for instance, within the National Human Rights Institute, in government ministry. We who go to that, to those kinds of bodies, from the civil society, for instance, are we coordinated? Or are we going to be seen as approaching the same individuals with the same coming at different points of time, and then perhaps even taking away from the time they have to do the actual implementation? So I propose that we have to be organized, and that would help the message of a collaborative approach, to reach the right audiences, and then we ensure that we are successful. But also we can consider, I think this has worked, provision of practical support models, concrete support legislation of the Commission, enactment of legislation to give effect to the human rights that are endangered by virtue of the failings within the national system. Legislation, but draft bills for legal reforms, support capacity building for legislators, assisting, for example, supporting education and health care, where we can, especially now that resources are becoming the most scarce. These are the real human rights issues. That's one, a few other people here have said. Human rights are not human rights here. The human rights are the concerns, the real challenges that are faced by that man or woman or whatever, by whatever gender they identify.
Brian Kibirambo is focused on, the presentation is focused on a very important point, which has to do with institutionalization of political will. It's not political individual, but rather individuals. Now I'll give the floor to Mr. Folusho Ade Gulu for 5 minutes. Mr. Folusho, we have 5 minutes.
National Human Rights Institute. I think it will be interesting. Brian and Commissioner Sema at the stop. It's very crucial, and this is the direct mandate of every national human rights institution, is to ensure with their obligation under international law. So this means that forms the direct mandate of national human rights. However, the question of role is one of the major constraints in face implementation. So in this regard, one of the initiatives we have been discussing in the different African national human rights institutions is actually the issue of a function following up on implementation when a particular individual is actually interested. It is actually something that we actually discussed in May during the African Union Commission policy dialogue that
we have with the different national human rights. So one of the immediate outcome from that declaration was NHRI implementation focal point. And the idea was to gravitate towards and I would want to say that Mr. Fat, who had actually presented in the morning from the CNDH of Morocco, is, for example, the implementation focal point for Morocco. And at the moment, we have 26 African states that have actually designated national human rights institution focal points. So what is the idea? I would just want to speak briefly in the remaining minutes on what the core feature of implementation, NHRI implementation unit should be like, and why this in the room can support this, and also how the African Commission can support the initiative. So, there should be a senior national human rights institution, a desk officer, continuity. So the role of the NHRI implementation unit is a tripartite engagement, which would involve engagement with the government, engagement with African human rights mechanism, and also engagement with civil society. The importance of this, of course, is that an ad hoc task force. So in my last NHRI implementation units can benefit two of the key stakeholders in the room, and this is for I like to encourage the different state actors in the room to officially NHRI implementation unit as their national monitoring and compliance, and this is to collect and gather information. Different history. The other call is resourcing adequate financial support, human rights implementation unit, and the last one for legislation from Parliament to actually give support to this. For the African, we have a few to support. The first working relationship implementation unit, and this can be done either by adopting a resolution or a guideline, formally recognizing them. The second one, of course, is establish a system. The presenter from the commission had mentioned that there are three, I think, focal points at the moment. So it will be important for to establish a system. Distance, which I think was also part of the needs of National Human Rights Institution. I would stop here in the interest of time. Thank you very much, Madam Moderator.
Merci beaucoup, monsieur. Votre intervention dans laquelle vous avez bien rappelé que les INDH dans les États africains sont un acteur principal, mais un partenaire principal de la Commission africaine des droits de l'homme et pour
on human and people's rights, and also the recommendations and decisions that come from the Commission. They have to take it on. And thank you so much for putting focus on institutionalization of these agencies who are very important for the necessity to designate focal persons, and also to recall us and debate on this conversation that we will have further discussions on in other discussions. Now I'll give the floor to Madam Sifiwe from Eswatini. You have the floor for 5 minutes, Madam.
for coordinating the preparation of state implementation of recommendations from human rights mechanisms. I am supposed of national actors in facilitating the implementation of decisions and recommendations of the African Commission. In Eswatini, the national as I stated, the mandate has the mandate to follow up on the implementation of recommendations from human rights mechanisms. What we do, we cluster the recommendations, including observations into thematic areas, and then we disseminate relevant stakeholders or implementers. This is of these recommendations, informing them that they or make plans for implementation of these recommendations. Track the implementation of recommendations ministry to implement the African Commission. This process by mapping, there is need to identify the relevant stakeholders, a contact list that will include civil society, important. The kind of recommendations to implement. These challenges in information. There's also for a collaborative effort among treaty payers to implementation meaningful. You find that most ministries work in silos, so there is need. And then how would these challenges at national level be addressed? There's need for implementation of recommendations and of implementation plans to track implementation and dissemination development of a web-based tool for track and report on the implementation of human rights recommendations under the United Nations. This tool is called the National Recommendations Track, which under the AU, this can help us. That would be it. Thank you so much.
And the Please.
Strategies that we consider to have been successful implementation of decisions, the African Commission. I'd prefer by saying first, in focus implementation, sometimes we miss the impact decisions made in national environment. Actually, that a state may appear not to have to the decision practice going forward. The state or state the issues that point when we focus exclusively on implementation. The other thing I'd like to preface is that implementation, as we have seen, is never complete. It's usually so that we may not be able to find able to say this has complete 100% implementation by. Third thing I would like to say also be in pointing out or identifying strategies, we must be careful and correlation because not necessarily have done from or not done, but because either first one, those would be the 3 points I'd like to preface. Now, the two cases to focus on the endurance are relating to indigenous people and people versus were decisions brought by open society. Now, in the first call implementation, endurance welfare. Beyond that, I'm not aware that major implementation has taken. We could keep that off as implementation. Now, for the people and the communication, I think that would be one of the situations can point to. But essentially, yes, that was the subject commission. What do we find as I'd like to quickly speak to perhaps the most on itself. I think in recent time the recommendations that then a situation two, I think the implementation have greatly improved specifically the use of, but also back to the commission to say, this is what you ordered, this is the implementation or non-implementation. That use of that mechanism is also very useful. It's both civil and strategic stakeholders. I think as up till now is that mission is diffuse so that because it deploys both the litigant on the side of I see in a minute. On the side is the fact have managed to affect and others on the decision from the food. What are then Commissioner just it's essential engage trade unions and other non-human rights, I'm using that in quotes, actors at the national level. I discussed expect us to engage with the opposition, but I just and any of the two main opposition, Peter Obi or Atiku Abubakar, mentioned the government would run into wherever it will go to ensure that it responds. I think the CSO table these issues and figures to ensure that we utilize those mechanisms. Thank you very much for the time.
Thank you, Professor. Thank you. Merci beaucoup, Professeur, pour ce constat.
Shared with us what works, what does not work to the incomplete implementation of the decision of the Commission, and also the strategies and the positions that you shared with us, and especially the need to engage other actors together with the ACHPR to ensure this implementation. Once again, thank you, Professor. Now I'll move to Dr. Antoine Landry Bologo, Alumbe, Cameroon. You have the floor, Doctor, for 5 minutes. Thank you, Commissioner, for giving me the floor. You know, it's very difficult to take the floor after the speakers who have spoken before me. But I'm going to try to go straight to the point, just as the others, share the experience of the Human Rights Commission that I'm representing here. The institution that I represent was created by a 2019 law. It was implemented in 2021 after the swearing in of the new members before the Supreme Court. Since the law of 2019, our mandate has moved from simply promoting and protecting human rights to, to a new mandate, which is to ensure prevention. Well, it plays the role of serving as a national mechanism that prevents torturing.
En tant que INDH, nous
As
avons un rôle principal, c'est celui du suivi.
a human rights institution, we have a major role. We monitor and we support government in terms of advocacy in ratifying and implementing instruments. Cameroon doesn't have a lot of concerns with regards to ratification because beyond the African Charter on Human and People's Rights, the African Charter on the well-being of the child, which were ratified before the creation of my institution, all the other instruments, we had to advocate for their ratification and their implementation through letters that were sent to authorities and recalls of the situation of human rights developed by the Commission on Human Rights in Cameroon. That is particularly the case of the Maputo Protocol, the Kampala Convention, and the Protocol on Older Persons and Persons with Disabilities. As a success story in terms of implementation, we can mention the letter that was sent to the Ministry of Foreign Affairs to ensure the ratification of instruments on promotion and protection of the rights of vulnerable people, which led to the position of the protocol, ratification of the protocol on older persons and persons living with disabilities in 2023. Also, we had a memorandum of understanding between CDAC and ACHPR on advocacy and the implementation of the Kampala Convention. And finally, in the annual report of 2022, there was a rubric on the state of human rights, and a section was dedicated to the state of ratification of African human rights instruments by Cameroon and recommendations in line with the need to revise or ensure the ratification process of the protocol on social security. The major challenge that CDHC faces is the possibility of having financial resources in order to carry out a campaign, an advocacy campaign with all the stakeholders to whom the implementation, the test need to be explained, to whom the test need to be explained with practical cases of situations that are lived by the by the institutions on a daily basis. I mentioned the third mandate, and there's an article that gives us the possibility to work as a friend of the court. This allows us to, in the case of the implementation of decisions or recommendations of the Commission or the African Court on Human Rights, to directly intervene when the Commission realizes that there is a dysfunctioning of the court. We signal the judge, and the Commission can directly meet the judges and talk about a case of violation of human rights by referring to international decisions or international conventions on human rights. This is progress that we've already achieved. At the court, we've not done it regionally yet because for now, the Commission has not seen in a case that requires that we work at a regional level. We do this at a regional level. Now, in terms of advocacy for implementation, I talked about the implementation of recommendations. Now, I'll tell you about a famous case, famous because of the people that were involved in this case. Is the Plus Njawe case, who is a very important person in the country. This person was arrested.
Alors que tous les droits qui sont les siens.
All his rights were not respected during his case, his court case, and we carried out actions in order to ensure that we are part of a committee that sat on the issue, a committee within the service of the Prime Minister. And after a lot of advocacy, the commission became a part of this committee. And besides, one of our colleagues was designated as a member of this committee, and so we were able to monitor the issue. We were invited to all the meetings that were carried out by the committee, and at the end of the day, the committee was able to decide that the issue of Mr. Plus Njawe should be judged in his presence with all the proof in order to bring him out of that situation. I would like to say that my direct boss, who is a magistrate called Dam Eseba, who had also been a vice chair of TCS, Special Criminal Court, the body in charge of judging people who had committed violations, financial violations, embezzlements. And so when he arrived, we were able to have decisions that were taken that the committee hadn't had access to by its own means. And so this really facilitated the work for us. Now, I'd like to thank all the organizers of this program. Thank you for having invited us. I would also like to say, because I heard the other speakers ask a lot of questions, I would like to say it's an honor to participate in this type of workshop, because when we participate in these types of workshops, maybe, for institutions like mine, sometimes we do not handle a lot of issues. But it's always good to know that there are other partners who are working on other domains and who give us strength. We have the civil society representatives and others here. This shows that the fight is not an individual one. It is something that we have partners, knowing that we have partners who help us to move forward. Thank you so much. Thank you so much, Dr. Antoine, for your presentation. You really talked about the evolution of the mandate of your institution, and then also the fact, the general mandate, you said that the commission is also one on human rights, and at the same time, it's part of the INPT. I think this is a particularity that we do not see in many African states, and this could inspire one or two institutions to replicate this good example. Thank you so much, Dr. Antoine. Now we move to our last speaker, Mr. Marcel Kwadjo of Cote d'Ivoire. Mr. Kwadjo, you have the floor for 5 minutes. Thank you, Commissioner. Good afternoon to you all. I'm taking the floor to talk about the case studies of successful implementation of decisions and recommendations of the ACHPR. I'm not going to focus too much on the decisions, but rather on the recommendations. Because from October 20, we are losing the speaker.
Excuse me.
How do you function for us to be able to implement these recommendations? We thought the recommendations, the implementation of the recommendations starts by the putting up a normative framework, institutional framework. That was done from setting up of the normative framework, because even if Cote d'Ivoire, the legal framework of Cote d'Ivoire is what we discussed this morning, you have to internalize or domesticate some of these relevant protocol. That was done. What was not there, we give a definition, for instance, to definition what rape is meant in Cote d'Ivoire, and rape is highly a criminal offense and it's penalized, and it's part of the criminal code of the country, and other measures were also taken. There's not much time for me to throw more light on those. But next year, Cote d'Ivoire will present their report to the African Commission regarding the Maputo Protocol, and we have more information which will be detailed there. Those are some of the best practices, and after that, there were some mechanisms that were put in place that include taking care of challenges that are linked to, and there are some programs that were also implemented in terms of gender-based violence. Projects were implemented. Today they have we have a cells for gender office, because the law that set up the constitution of 2016 on Article 16 gives the power to the state and the local government ministry to promote the right of women. So we have gender cells or offices in all government offices throughout the country. So we are also promoting equality between women and men, because the Maputo Protocol also speaks about equality. So there are also positive progress. During the colonial era, there was also institutional discrimination against women. So Cote d'Ivoire also put in measures with some centers for young women to empower them. We also have boarding schools specialized for young girls, so that we can also promote education in the country. We also initiated a construction of schools in the various communities. So we realize that there's issue of distance that makes the girls to travel long distances to attend school. Because of that, they're exposed to some of these rapists. So we try to build schools closer to communities. What was interesting about all this in the various technical ministries were put together to promote women's rights, namely Ministry of Family and Children, Ministry in charge of Justice, Ministry of National Education. These are some of the key agencies put together. In addition to that, the government of Cote d'Ivoire tried to centralize these decisions through an organization we call OM, the National Roadmap for Equality, which is based at the office of the Prime Minister. Meaning that the minister and the head of government, who is the Prime Minister, has the responsibility and oversight responsibility of these decisions. So that also enables us for this agency to be centralized and take all decisions and needs that have to do with promotion of women in the various sectors of the country, or the various local governments of the country. So there's no challenge over taking care of women in the country. This also enables us to deal with the various recommendations. Today, in terms of empowerment of women, several agencies are put in place. Accra, that's the highest agency, which is a fund special by the First Lady. There's a special fund for the lady to empower women financially, for them to take up entrepreneurship roles. We also have a law related to marriage. Today in Cote d'Ivoire, couples are equal in terms of marriage. So in Cote d'Ivoire, and a clear example is that the marriage certificate is given to both man and woman. Those days, symbolically, the marriage certificate is given to the man separately, but now there are other changes. There's also a possibility that the woman can also add his name to that of the children from the marriage. Those days, those things were not there, but now these things are coming in place. So there's also a lot. We're also taking out some laws that discriminates in terms of inheritance, and when someone dies interstate. So all these laws are in place. So these are some of the things that were put together. Now, what is the challenge in the implementation? Generally, social cultural challenges. As you may be aware, the laws are there, but there's education, and we have what you and your culture. So that impedes the implementation of these laws. For instance, when we during meetings in the women, we tell the women that often a woman is the head. You realize that all the people the woman is working with, they are women. How do you manage that? To promote that, you have to promote. If you want to promote the right of women, you also have to promote, empower women for them to be equally qualified to take key roles. That's why we realize that since these were implemented, the women were actually taking up more role. Sometimes the women actually don't want to work with the women. They prefer to work with men. They have this mentality that they can't be on their own. These are cultural things that is very difficult for us to deal with. There's also the fact that there's sensitization that is not has not settled in well. The laws are there, but sensitization, education on the laws, explaining the law to the people at the grassroots. For instance, a lady who is in the rural area is not. It's a challenge. Now, how do we do that for them to tell them about their rights? If you don't know your rights, it means that somebody can equally abuse you. So those are another challenge that we face. I want to say that monitoring of these recommendations, we have NGOs, CSOs, we have the national HRS, and the International Committee on Human Rights. They monitor all these international instruments. There's also sort of coordination between these agencies that monitor these rights and implementation. Thank you very much for your kind attention. Thank you, Mr. Kwadwo, for your presentation and sharing this wonderful experience with us from Côte d'Ivoire. You focus on the right of women, the protocol, Maputo Protocol, and this experience can actually help the other member states to actually take inspiration to implement similar projects in their countries. We are going to sessions 7 and 8. So once again, let's put our hands together for all the panelists. Let's give them. Since we are behind time, I'm going to the audience and open the floor for discussions and maybe take 1 or 2 questions or remarks. 3 questions. The floor is yours, audience.
From the last, he touched, I wanted to ask my question. Who monitors the grassroots in the communities? And we have a lot in this treaty.
Now, our activities can be captured from coalition, by the coalition that we belong to. We report to them. But I want to tell you that a lot of many other, lot of outstanding communities, now those work, how do they get captured and reported? You may find out of this, and they are not being captured. They are not even being reported anywhere. So my question is, how are these being captured? And a lot of these organizations they are not human rights. They don't call them human rights activities. They do what they do. Many of them don't even know about any of these treaties. When we were trying to empowering communities with the provisions, many of these people, human rights alliance, they don't even know about Maputo Protocol, So my question is, how are these church and how are they being monitored to even do what they should do and make better impact? Thank you.
Merci, Madame. Une autre question?
Non, merci. Moi, c'est pas une question, c'est un commentaire. J'espère que je peux y aller. Concernant la judiciarisation, la justiciabilité des droits dont nous parlons.
Principles. Or friends. Two. First is, why are member states in a hurry to ratify United Nations conventions, and then they delegate to the background regional and continental instruments? Is it to please the West, to please international community, to benefit from credits, from loans, from international aid, IMF, World Bank, etc.? I think that we need to change this trend, and we need to make our priorities straight, set our priorities straight. We need to prioritize the continent's instruments before the international one. Now, someone talked about proliferation of legal instruments, and this is very important. Sometimes there are duplication, some not unjustified duplications, and so I believe it is important to harmonize or review our legal frameworks in order to prevent this proliferation of tests and ensure that we carry out impact studies. Today, in terms of codification, we have the American School of Thought that says that the norms or standards that are not applicable, they do not need to exist. And so it is also important to look at this issue of proliferation of tests. The last thing that was said by the speaker who just talked about it, justice, the intervention with the court. The African court is evolving, and I take the example of our judges, the judges in our Roman German law. we do not have international courts, and the courts on human rights. I have 25 years of experience, and privatism it is not within human rights, and this impacts jurisprudence, and this impacts human rights. And so I think that the Banjul Commission needs to carry out capacity building workshops for human rights defenders, human rights activists, judges, and lawyers. And the last is we are in Nkrumah's country. He was a leader, a Pan-African leader. And today we are seeing a regression of Pan-Africanism. So where is this unity? Where is this the solidarity? Where is this will to live together, this community of values? Because this is what's going to push the ratification of our legal instruments. And for this, maybe we need a new generation of leaders who will unite us. Thank you.
The fundamental human rights enforcement. That enforcement
She wants to respond.
No, but she has to give you the floor now because there is one question for the panelists and then we wrap up. Are you getting it?
I don't understand.
There is one question for your panelists. If they respond, then you wrap up because
No, I'm not part of the panel. How can I wrap up for the panel? I'm not supposed to wrap up. I'm not in the panel.
Yeah, Commissioner, go ahead.
Okay. Thank you very much. That has come from Flo. I think somebody interacting with the opposition. I do agree with you, and it's not unusual for the Commission to interact with the opposition. Because when we embark on a Commission mission, we interact with the legislation. And when we interact with the legislation, we don't make a distinction. This is an example of a Commission mission in Namibia. And based on the QOR that we have interacted with the Parliament, we had a session on the leaders of the opposition, and we were able to share the feedback. It's also reality. It's not one size fits all. Procedure. Some you find their laws based on the and I use Namibia as an example. You said that you did X, Y, and Z. To recognize the fact taking a very deliberate and intentional step in terms of implementation and monitoring by the established implementation, track, monitoring and implementation of instruments that no, not only instruments, but the decision And I do agree with you that sometimes the judiciary has... Hello? No, this one is better. Can you hear me? Because of those votes, the Supreme Court has taken a very bold step of actually allowing treaties and the current Chief Justice the decision. Even though it is not incorporated, he traces the and it's significant for the country. And most importantly, the fact it can be actually used proactively as an aid to interpretation. Not only that, but those into human rights standards actually fall into the realm of customary international law. And you know when it comes to customary international law, you don't need incorporation. And have judicial decisions implemented. And that is for both the Commission and the committee. And need to do something. And that is why for everybody to play a role, to promote an incentive or incentives, but just working very hard, being as specific as we can be to ensure implementation of decisions. And perhaps so our sitting African Commission had the opportunity to receive communication who actually come to the Commission when there are survivors. So remember that today you are current president, you are former president. And if you develop the institutional of implementing decisions, and you will not be able to benefit from this. To grasp it. Because that even the together with so at that level, we have an obligation for all the measures that are on the ground for implementation. If that fails, there are some initial CSOs stakeholders bring to the Commission. So when your country or any country you still have opportunity to present a solution. Make sure that you give us the food. So the mechanisms are there. Maybe the survey, public sessions. Every time a country is reporting, liberty to ensure that we bring information to complete the picture, so that as collectively we can ensure implementation. So, and this goes to, and I said it in the litigating women's rights. I think it is important that CSO, the recommendations, decisions, and human rights mechanism for advocacy. So if we are on the ground, we always interact with we share the recommendation. So we would like to see using our recommendations these days seem to be very transformative. It's not just about come to the Commission, it's about institutional. So if that's reform, I think you should be using as advocacy tools to advocate and make sure that the state is held accountable. In addition to the steps that we are taking at the African Commission to ensure implementation. Thank you.
Merci.
Just what has been said. First, all of you colleagues, for your kind indulgence and understanding in respect to our request to rationalize the program. We are very grateful for your kindness. I was, maybe as I was going out, in and out, I might have missed it. But I don't know if there was any mention of Article 25 of the African Charter. Article 25, was it mentioned? Okay. Now, we are talking about implementation, and yet we haven't mentioned Article 25. And that, I think, is going to be a very serious. That's why I would like to read what Article 25 states. It addresses, you can read into that all other actors as well. I quote, the present charter shall have the duty to promote and ensure through teaching, education, publication, the respect of the rights, and to, as well as correspond. This that we need to engage when we talk about implementation of the rights and freedoms, duties and obligations in people's rights. Read together with Article 26. These two provisions, because they happen on a borderline between the chapter of the Charter Article 25. Okay, that is where some of the issues, conscious, I think colleagues may, I'm sure, our actions of consciousness, what? And habit. Consciousness. And we have to, among all sectors, in order for us really to bridge this that exists, what is contained, and the kind of life people live, a life that is stripped of the basic instruments of the vast majority of people. All right? And this actually lies for us. Because it's neither the attempt to say that is neither the attempt to create narratives neither here nor there. And also define. Okay? For example, we talk about sometimes political will and resource. It's not lack of resources. It is that where resources that we have the problem with. That is why is And we need, therefore, to broaden our engagement around these issues. In terms of the work of the African Commission, I think the suggestions and colleagues, we very much appreciate that. And together with you, we would integrate those into expanding and strengthening the working methods of the Commission. But it's also as of the human rights institution, I think we have been discussing and initiated. So if you the Maputo Protocol and so on and so forth. When we do promotion mission in the course of this week in Ghana, we raise where are they? Well, what are the challenges executed? And many of the other issues that you raised. And in our concluding observations in the advocacy missions that we undertake and in the ordinary sessions that you all are part of. I think it was the African Charter is the universally instrument of the African Union human rights, the African Union system. Perhaps City Act, which has universal ratification, and the African Charter has -1. And we have that country here, Morocco, and the National Human Rights Institution. And I hope with your collaboration and advocacy, it wouldn't be long before having Morocco to be part and parcel of the African Charter human rights system. Thank you very much, Commissioner, and to all of you colleagues.
Merci beaucoup à tous les intervenants pour vos commentaires, pour vos rajouts, pour l'enrichissement. Nous arrivons à la fin de cette session.
Close gradually. It was a day rich in experience sharing, rich in discussions, rich in new ideas, and even original ones. I'm not going to take the floor too long to conclude these two sessions. I would like to simply recall the ACHPR motto that human rights are our collective responsibility. Ladies and gentlemen, delegates of states, representatives of CSOs, NHRIs, Commission of the African Union, that when you move back to your countries, ensure that what we discussed is disseminated and experienced in the lives of people. Ladies and gentlemen, thank you so much, and I wish you a good evening. Thank you, Honorable Commissioner Sassy, for the mastery with which you led these two sessions. Thank you to the panelists. Bravo to you guys. Another round of applause for them, please. Thank you. Thank you. We're going to do everything possible for the closing ceremony tomorrow to be a closing ceremony only. There is an issue we're going to resolve now. First of all, there is an evaluation form that has been sent to you by email. Tomorrow, after the closing ceremony, we will expect you to send us this study because it will help us in future meetings. Thank you so much for your indulgence. Now, I think tomorrow we'll have the closing ceremony. You need to be here on time. And we have these gadgets are still here. Someone lost it. Thank you. We found the owner. We are going to close today's meeting with a reading by colleague Dr. Ayeni. In 6 minutes, he's going to talk about the recommendations. So in 5 minutes, please indulge us. After that, the documents will be shared for inputs in a mailing list that we have so that you can also add further documents. When he's done reading, it will be my role to tell you good evening. So Dr. Ayemi, please come to the podium for the reading. 5 minutes. I plead your indulgence, dear participants. Thank you.
No.
And digitize all recommendations from various mechanisms. Create a system to directly notify NHRIs of the adoption of decisions and recommendations for implementation by state parties. Formalize working relationships with NHRI persons to enhance their role in implementation monitoring. Establish recommendations management system that will help state parties and government departments to know the type of recommendations they are expected to implement. Continue to ensure clarity in its recommendations, which seems to have contributed to enhancing the implementation of its decisions. Continue its strategic engagement with CSOs and national actors that has been identified as one of the factors responsible for the implementation of this decision. Devise strategic ways to engage professional associations, trade unions, and other groups at national level. There are other recommendations noted which are not incorporated. These are just work in progress. We are still going to review them. We are still going to listen to all the videos to pick out the recommendations. Thank you.
Thank you, Dr. Ayeni. And I think we are going to call it a day with the kind of commission of the vice chairperson who is heading all this event here. So don't forget to fill out the post-event feedback survey. The prompt after the closing ceremony, we'll be expecting it at the secretariat. Ladies and gentlemen, have a good night, and probably tomorrow we will understand why we are shorting this activity. Thank you.
Demain à 9h, il y aura l'enregistrement. Demain à 9h, cérémonie de clôture. Merci beaucoup. Demain à 9h, cérémonie de clôture.
Closing ceremony tomorrow at 9. Closing ceremony tomorrow at 9. If you need anything, the secretariat is there to help you. Thank you.